ವೆಕೇಟಿಂಗ್ ಇಂಟ್ರಿ ಮಾಡೋರಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀವಿ. ನಾವು ಹಿಯರಿಂಗ್ ಅನ್ನು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಾ ಅಥವಾ ಹಂಗೆ ಕೊಡ್ಬೋದು? ಹಿಯರಿಂಗ್ ಅಲ್ಲ, ವೆಕೇಟಿಂಗ್ ಇಂಟ್ರಿ ಮಾಡೋರಿಗೆ ಯಾಕೆ? ಲಾಸ್ಟ್ ವೀಕ್
I could not have I have not seen the link.
Lord, sir. Covered by judgment, my lord, sir. Only to Mandamus, seeking Mandamus for matter of law. Have it tomorrow.
ಇಂಟ್ರೆಸ್ಟ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಸಮಯ ಅದರಲ್ಲಿ ಮಾರಾಟ ಮಾಡಕ್ಕೆ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
It could be.
But your lordship's kind permission, one mention, my lords.
it's not one mention, if I'm allowed to make, my lords. Your lordships may recollect, there was one writ petition your lordships were hearing regarding this 18-kilometer radius from the periphery of, it was, I'm told, my lord, it was listed last week and it was supposed to come up this week, Bandila. If, subject to your lordship's convenience, if it could be taken up, my only urgency is this, my lords. Central funds have been given to the Rajiv Gandhi Housing Corporation. Those funds will lapse on March 31st. So subject to your lordship's convenience, any day next week, my lords, we'll take our chance. 2:30 adre, but I don't want to trouble my lords with because once the 31st goes, because the funds have come from central government, those funds lapse, my lords, then again the funds will have to be reapplied for, it has to come back. Because those lands, my lords, were subsequently allotted to the Rajiv Gandhi Housing Corporation. So if your lordship's order, previous order, your lordship may recollect, where to measure this 18-kilometer distance. Now a report is filed. Therefore, if the writ petition is dismissed, at least we can proceed with the construction. My lords. Grateful.
Portion of the land for 50 years. Learning and industry. There are around 900 people working there. Trying to take it up. No, my lord, there's certain.
What is that?
Sir. Yeah, tomorrow.
My lord, serial number 26.
Even though
I have informed them, my lords. Excuse me.
Very same order challenged in another writ petition, my lord. WP 6008/23. Yes. Very same order challenged in another writ petition 600483. That notice is order in my lord.
Only notice,
Notice.
only notice.
But here, my lord.
We have the writ petition of the
600.
600
8/2023.
2023.
23.
Learned HCP takes notice for all the respondents. Learned counsel for petitioners is directed to serve a copy of the petition along with the annexure to the learned HCP. Full stop. Next para. List this matter along with WP number 6008 of 2023.
Non-position of the petition before the second respondent. It filed a IF for recalling the order, but passed an order of impugnated order unnecessary, your lordship. You know, the petitioner, second respondent passed and dismissed for non-provision before the petition. He filed IF for recalling the order before the second respondent. Second respondent passed an order unnecessary, page number 19. Recall madak baradilla ನೀವು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಆಗಿರೋದ್ರಿಂದ ಅಂದ್ರೆ ರೀಕಾಲ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳಿ ಡಿಸ್ಮಿಸ್ issued endorsement unnecessary page number 19 your lordship. Imbadha.
So you will have to challenge both the orders, not only the order of order on IA. Madak baradilla.
Your lordship.
They don't have powers. Simply because you file an application, the court has to pass orders on that IA. Madak baradilla. You will have to challenge that original order.
If I did
Do not challenge the original order.
you challenge the original order,
Then we will issue notice on that.
your lordship, moreover, you filed a written argument before the second respondent, but they are not considered those.
See, so therefore you should have challenged that order itself. How can you file an application before the authority? They have not powers to recall their own order.
That's why I'm filing this petition.
What have you challenged here?
Unnecessary
Annexure A only.
unnecessary and
Madak
partially
baradilla.
ordered 67 unnecessary and along with the unnecessary. If you lordship, page number.
Want to raise a challenge to the, you are not furnished a copy of that order,
Furnish you.
the original order.
Furnish you
So you challenge that order also.
before this.
That order itself had to be challenged, not the order on IA. ಹಾಕಿದಿರ ತಾನೆ ಅದನ್ನ?
ಹಾಕಿದೀವಿ application.
Please challenge that one. you please file an application for amendment of the prayer.
Moreover, for a minute, shall I read unnecessary your lordship?
ಅರ್ಥನೇ ಆಗಲ್ಲ ಅವ್ರು ನಿಮ್ಗೆ ಹೇಳಿದ್ರೆ.
ಗೊತ್ತಾಯ್ತು.
The authority has no power to recall his own order.
Yes, your lordship.
So therefore, Annexure A order is in accordance with law.
Yes, your lordship.
What to do?
You have to submit before the same.
ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು, file an application, seek amendment of the prayer, raise a challenge to the original order passed by the authority. Anyway, it is here on record.
Yes, your lordship.
Then learned HCGP takes notice for response number
1 to 5.
1 to 5.
PVMP.
1 to 5.
I
1
appear
to
for
5.
14th respond.
1 to 5.
Learned Counsel Sri GB Manjunath
Yes,
14.
respond number 14.
has entered appearance for respond number 14 only, na?
14 ಒಬ್ಬರೇ ಬಂದಿದ್ದು ನನ್ನ ಹತ್ರ, ಅದು ಕೇವೇಟ್ ಹಾಕಿದ್ದು. ಉಳಿದ್ರೆ ಯಾರು ಬರ್ಲಿಲ್ಲ.
Issue notice to response number 6 to 13
13 and
and 15 to
20.
24.
24.
24.
Learned Counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned HCG. Full stop. Next para. Since the petitioner has raised a challenge to the endorsement at annexure A issued by
Second.
the second respondent, Regional Joint Director of Land Records, and not to the main order at annexure B, learned counsel seeks for a short accommodation to file necessary application to seek amendment to the prayer.
Still, your worship,
And-
annexure B. Sorry, prayer B, your worship, washing the order 6/7/2018, possibly second and annexure B, restore the petition. Annexure B is
Yeah.
our prayer. Yes, your worship. Prayer is there. Second prayer.
All right. Yes, what do you say?
In this case, my lord, the Lingegowda's sons,
He is simply saying
this is,
annexure B has been passed
yes,
without giving opportunity of hearing to me.
your lordship will kindly
And
see.
he has not considered the contentions raised in the written
Other
argument.
arguments also, that's.
Please, your lordship will kindly see the page 21,
Yes,
annexure A,
yes.
annexure B, page 21.
ಏನ್ರಿ one
Second para, your lordship.
one paragraph.
ಒಂದೇ
How can
only
you
one
sustain
paragraph.
this?
ರಿವಿಷನ್ ಅರ್ಜಿಯನ್ನು
ಹ್ಮ್.
ಮೂಲತಃ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ರವರ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 24/3 ಸಲ್ಲಿಸಿದ್ದು ವಿಚಾರಣಾ ನಡವಳಿಕೆಯ ಪ್ರಕರಣವನ್ನು ಆದೇಶ ಬದಲಾವಣೆಗಾಗಿ ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ವರ್ಗಾವಣೆಯಾದಂತೆ ಪ್ರಕರಣ ದಾಖಲೆ ವಿಚಾರಣೆಯನ್ನು ದಿನಾಂಕ 12/8/29/36
ಆಯ್ತು ಬಿಡಿ, dates
all these
ಕೊಡ್ಬೇಡಿ.
dates,
ಆಯ್ತು.
your lordship further madam.
ಹಾ.
ವಿಚಾರಣಾ ದಿನಾಂಕಗಳಲ್ಲಿ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರ ಬಗ್ಗೆ ಸತತ ಗೈರು ಹಾಜರಾಗಿರುವುದರಿಂದ ಕಂಟಿನ್ಯೂಸ್ಲಿ is absent.
ಹಾ. What about the written arguments?
Written arguments he has not stated he has filed it or not.
If I did page 125,
ಹೇಳ್ತಾರೆ ಇಲ್ಲಿ
kindly see page number 125, my written argument, petition
Page number?
present, page number 125. Typed copy.
nowhere it is stated. in the
Petitioner
order he
present,
has filed
files
it.
return arguments,
Yes.
memo, IO extended, urgent to, as per the request of submit judgment copy and land grabbing court, column so and so.
In the order-
Unassured is my written arguments.
In the order it is not stated.
Unassured is my written arguments also produced before this court.
ಹಂಗಂದ್ರೆ
In this case, my lord, the father of the petitioners have taken.
minutes ಮೇಲೆ
company-
ಕೇಳ್ತಾ ಇಲ್ಲ.
let him
Just
consider
remind
the matter on merit, sir,
Mates ಮೇಲೆ ಕೇಳ್ತಾ ಇಲ್ಲ ನಾನು.
affording an opportunity to them.
That is also,
We'll have to remand the matter, sir,
That's
for
also.
fresh consideration.
that's law.
ಅದು ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದನ್ನ ಆ BBMP ಮತ್ತೆ ಇದ್ರದ್ದು ಮಿಕ್ಕಿದ್ದು ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ನಂಬರ್ 6 to 13 ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ಅದನ್ನ ತೆಗ್ದಾಕ್ಬಿಡಿ. ಅದು ಮತ್ತೆ 15 to so and so ತೆಗ್ದಾಕ್ಬಿಡಿ. Notice to the other respondents may not be necessary for the following reasons. Next para. Learned counsel for the petitioner submits that the order at annexure B has been passed by the second respondent, Regional Joint Director of Land Records, Bangalore Division, without considering the written arguments submitted by the petitioner. Full stop. Learned Counsel submits that in the order at Annexure B, the Joint Director has simply said that in spite of several opportunities being given to the respondent or petitioner,
ಅಲ್ಲಿ ಅವ್ರ ಪಿಟಿಷನ್
Petitioners.
to the petitioner, there is no representation for the petitioner. Although the petitioner is represented, the appellant is represented by a learned counsel. Full stop. Learned counsel draws the attention of this court to the order sheet maintained by the Regional Joint Director at Annexure
Annexure
G,
G, Your Worship. Entire order.
and points out to the order dated
Order dated, Your Worship. 3990.
page number,
Page number 125, typed copy, Your Worship. Last para. Petitioner present, files written argument.
ಅದೇನ್ ಡೇಟ್ ಅದು?
Date, Your Worship. 3/8/2019. ಮುಂದು
ಹಾ?
3/8/2019.
3/8/2019, wherein it has been noted that the petitioner is present and he files written arguments. Full stop. Next para. Learned counsel further submits that having noticed the fact that the orders were passed without hearing the petitioner, the petitioners filed an application on 6/7/2023 to recall the order dated
Order dated, Your Worship, 6/7/2023.
6/7/2023. ಅವತ್ತೇ ಹಾಕಿದ್ರಾ? ಯಾವತ್ತು ಹಾಕಿದ್ರಿ ಅಪ್ಲಿಕೇಶನ್?
Application filed on Your Worship. Your Worship, 5/10/2023.
5/10/2023.
I see, Your Worship.
Was filed on 5/10/2023 to recall the order dated 6/7/2023. Full stop. Nevertheless, the Regional Joint Director has issued the impugned endorsement dated 7/12/2023, stating that he has no authority to recall his own order. Full stop. Next para. For contra, learned counsel for respondent number 14 seeks to contend that the Regional Joint Director has noticed in the order at Annexure B the dates on which the matter was heard and there was no representation for the petitioner. Full stop. Next para. Having regard to the admitted facts that although a written argument was filed at the hands of the petitioner herein, the Regional Joint Director has not taken note of the contents of the written arguments. Full stop. That being the position, the impugned order at Annexure B dated 6/7/2023 cannot be sustained. Full stop. This court is, however, of the opinion that the endorsement dated 7/12/2023 issued by the Regional Joint Director cannot be faulted, since the authority is right when he says that he has no power to recall his own order. Full stop. Next para. Consequently, the writ petition is partly allowed. Full stop. The impugned order at Annexure B dated 6/7/2023 is hereby quashed and set aside. Full stop. The matter stands remanded back to the second respondent, Regional Joint Director of Land Records, Bangalore Division, to reconsider the matter, afford an opportunity of hearing to the rival claimants and thereafter proceed to pass orders in accordance with laws. Full stop. Ordered accordingly.
Date may be fixed to appear before this one, my lord, and time schedule may be time bound.
The parties are directed to appear before the second respondent on 18th of March, 2024, without waiting for further notice.
Time bound.
And time schedule 3 months, 2 months.
The second respondent shall consider
Within 2 months.
the matter in terms of the directions issued by this court and dispose of the same
Within 2 months.
as expeditiously as possible and at any rate within a period of 2 months from 18/3/2020.
Election ಬಂದ್ಬಿಡುದು.
Huh?
ಅಷ್ಟೇ ಎಲೆಕ್ಷನ್ ಬಂದ್ಬಿಡುತ್ತೆ 2 months ಅಂತ.
Election
Central government elections.
ಅದಕ್ಕೆ regional joint director ಅದಕ್ಕೆ ಏನ್ರಿ ಸಂಬಂಧ?
for the petitioners council. Third, the land where a temporary lease was granted in the year 1961 for 5 years. Later on, an application was filed seeking permanent grant. That is granted in the year 1989, my lord. Thereafter, mutation was made in the name of Narsaya, Iraya, and it continued after his death. It is in the name of his son. There was a partition subsequently, and it was allotted to one of the son. It is also granted to him. Thereafter, in 2010, for the first time, the fifth respondent here, in fourth respondent, her husband would make an application seeking change of mutation entry on the basis of said to have been granted in the land being granted in the year 1983.
To whom?
To him,
1983.
83 ಅಲ್ಲಿ grant ಆಗಿದೆ ಅಂತ
ಹಾ.
ಒಂದು application ಕೊಡ್ತಾರೆ.
ಹಾ.
Based on that, mutation entry is made in his name. I have challenged that before the deputy commissioner. Deputy commissioner rejects my petition. That is challenged before my lord.
On what ground?
On the ground that he doesn't speak anything about the grant which is made in my favor. In fact, a similar matter, similar in the sense, there are two portions here. One was with regard to 2.5 acres, 2 acres 30 good. That had come before my lord on 29,
So this
My
is
lord
in
was-
respect to other portion.
other portion. And this very same DC would pass an order. In that order, there was a reference with regard to the permanent grant in the year 1989. But in the present, there is no such mention also.
Learned HCP takes notice for response number 1 to 4. Issue notice to respond number 5. Learned counsel for petitioners is directed to serve a copy of the writ petition along with annexures on the learned HCP. Full stop. Next para. Learned counsel submits that in respect of the neighboring
Please.
portion of the lands, this court in WP number 3175 of 2024, by order dated 29/2/2024, has stayed the operation of the impugned orders.
I said A and B, my lord. ಅದರಲ್ಲಿ D ಅಂತ ಇದೆ.
Impugned orders, full stop. Learned counsel prays for similar orders.
Please.
Full stop. Next para. Consequently, there shall be an ad interim order of the impugned orders at
Annexure A and B, my lord.
A and B
A and B,
till the next date of hearing.
please.
Full stop. List this matter along with WP number
3-1,
3175 of 2020.
please.
ಇದು ವಾಪಸ್ ಕೊಡ್ತೀವಿ ಅವರು.
Your lordship, the factual matrix of this matter is similar to another WP that your lordship was pleased to hear.
Interim orders have been passed.
Please, my lord. And the factual matrix is similar in all material aspects, except the survey number is different, extent of land is different. And this is the case where the assistant commissioner set aside the mutation entry by the Tahsildar.
For that B and SC matter.
Please, my lord, yes.
This pertains to another piece of land.
Another piece of land, my lord, which was also said to be executed under the will by the deceased mother-in-law, which
Same order some.
is
ಇವಾಗ ನಾವು ಈ ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟರ್ ಮಾಡ್ತಿಲ್ಲ ಅದೇ ತರ. HCDP for response number 1 to 3. Issue notice to response number 4 to 6. ಆಮೇಲೆ interim orders passed in WP number 5305 of 2024, dated 23/2/2024. Yes,
In respect of annexures A and B in this petition, my lord. we have
A and B. Here also it is A and B.
A and B.
Yes. You will have to file online application. Please file online application. It will be done in 2 months. Yes.
For the petitioner. Lord, annexure A notice is challenged, was challenged. A composite notice, combined notice under section 67 and 39 of the Land Revenue Act, seeking handing over of the possession, alleged encroached land. According to the government, my lord, it is land is encroached by us 1.5 acres. Notice was given by the Tashildar as per annexure A combined under section 67 and 39. So now, my lord, what they have done is we filed this writ petition. Now they have taken over the possession of this thing. They have really hacked it. The writ petition may have to be amended. The writ petition is principally filed on the ground that, my lord, annexure A notice as given, that is combined under section 67 and 39 is cannot be, because no inquiry has to be held under section 67 and 39 is merely executory in nature. After holding an inquiry under 67 and after passing a formal order, then the authority can resort to section 39. Both ಎರಡನ್ನು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು that was the principal contention which is raised in the writ petition. ನಾವು ಹೇಳಿದ್ವಿ writ petition ಹಾಕಿದೀವಿ ಅಂತ ಅಂದ್ರೂ they have taken over the possession. Now the writ petition may have to be amended. ಇದರಲ್ಲಿ 67 and 39 ಎರಡನ್ನು ಒಟ್ಟಿಗೆ ಒಂದ್ಸಲಿ ಕೊಟ್ಬಿಟ್ಟು they have taken the possession. We are the owners of survey number 2/33 ಮೇಲೆ 3.49 acres. Abutting the said land is survey number 1, which is a Urguppe or Paisari land, which is classified as government land in the records. The government's contention is that we have encroached 1.5 acres anta helbodu. Now they issue this notice. Now we are in possession right from 1988. They issue this notice in 2024, my lord, under section 67, read with 39.
ಅಲ್ಲ possession ಅಂತಂದ್ರೆ only on the basis of
There are standing crops ಇದೆ. ನಾನಿದ್ದೀನಿ.
only on the basis of possession.
ಅಲ್ಲ only on the basis of possession ಅಂತ ಹೇಳಿದ್ರೆ our contention is that ಅದು ನಾವು 2/33 ಬರ್ತದೆ, not survey number 1 ಗೆ ಬರೋದಿಲ್ಲ ಅನ್ನೋದು.
ಆಯ್ತು. But what is your title over the property?
Well, it is the land forms part of 2/33 is our contention. Their contention is that land forms part
All
of
land though, how have you acquired title?
by virtue of I inherited through my father.
Huh?
I inherited from my father.
KL
Veerappa. I'm in possession of the land now.
So you did not give any reply, written reply?
ಎಲ್ಲಾನು ಕೊಟ್ಟಿದ್ವಿ ಸ್ವಾಮಿ. I have annexure C, D, E may be perused.
Yes. Yes.
ಕೊಟ್ಟಿದೀವಿ ನಾವು ಎಲ್ಲದಕ್ಕೂ ಕೊಟ್ಟಿದೀವಿ. ಸರ್ವೆಗೆ ಅವರು
Please read, sir. ನೀವು ಕೊಟ್ಟಿದ್ರೆ please show that this is the stand taken by us.
My lord, kindly come to page number 27.
Yes.
ನಾವು ನೋಟಿಸಿನಲ್ಲಿ ನಮೂದಿಸಿರುವ ವಿಷಯವು ವಸ್ತುವು ಸಿವಿಲ್ ವ್ಯಾಜ್ಯಕ್ಕೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ. ಈ ಸಂಬಂಧ ಯಾವುದೇ ಮುಂದಿನ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳದೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಬೆಂಗಳೂರು ಇಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ದಾಖಲ. ದೇರ್ ಇಸ್ another ರಿಟ್ ಪಿಟಿಷನ್ which is pending. LB ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಫಸ್ಟ್ ಪಂಚಾಯತ್ ಅವ್ರು ಬಂದ್ರು ಸ್ವಾಮಿ. ನಾವು ಅದನ್ನ LB ಅದ್ರಲ್ಲಿ there is a status quo order granted. ನೀವು ನೋಟಿಸಿನಲ್ಲಿ ತಿಳಿಸಿರುವ ಸರ್ವೆ ನಂಬರ್ 1 ಮತ್ತು ಆರೋಗ್ಯ ಇಲಾಖೆಯ ಕಟ್ಟಡ ಎಂಬ ವಿಷಯವು ಸಿವಿಲ್ ವ್ಯಾಜ್ಯಕ್ಕೆ ಒಳಪಟ್ಟದ್ದು. ಆದ್ದರಿಂದ ಅರ್ಜಿದಾರರಾದ ಗೌರಮ್ಮ ಕೋಂ ಲೇಟ್ ಸೋಮಣ್ಣ ಮತ್ತು ವಿಮಲಾ ಕೋಂ ನಾಗರಾಜು ಆದ ನಾವುಗಳು ಆರೋಗ್ಯ ಇಲಾಖೆ ಅಧಿಕಾರಿಗಳು
Not saying anything regarding your title.
This is subsequent prior to the said notice.
Sorry, I am only asking them, what is the claim, what is the basis of your claim?
Not the basis.
If you are not showing any right duly vested, but you are trying to protect your possession only on the ground that you have been in
ಸರ್ವೆ ಸರಿಯಾಗಿ ಮಾಡಿಲ್ಲ.
long possession.
ಸರ್ವೆ 2/30.
ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ? Where have you stated?
I have annexed all the replies, my lord. Annexure E.
In your reply, you should say so, sir.
Alla,
This is not the survey number what you are talking of. This is survey number so and so.
Correct, sir.
This has come to me by so and so. My forefathers purchased it.
ಅಲ್ಲ ಅದನ್ನ ನಾನು ಎಲ್ಲ ಕಡೆ ಹೇಳಿದೀನಿ ಸ್ವಾಮಿ. Annexure E, F, G, H ಎಲ್ಲಾ ಕಡೆ ಹೇಳಿದೀನಿ. ನಾನು ಎಲ್ಲಾದ್ರೂ ಓದ್ಬೇಕಾಗತ್ತೆ ಸ್ವಾಮಿ. ಎಲ್ಲಾನು ಹೇಳಿದೀನಿ ನಾನು. ಡೀಟೇಲ್ ಆಗಿ ಹೇಳಿದೀನಿ.
ಎಲ್ಲಿ ಹೇಳಿದೆ? You not started. Please show.
Annexure E, F, G.
E ಎಲ್ಲಿ ಹೇಳಿಲ್ಲ.
F ಅಲ್ಲಿ ಸ್ವಾಮಿ. ಸರ್ವೆಗೆ ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ. ಅದ್ರಲ್ಲಿ ನಾನು F ಅಲ್ಲೂ ಹೇಳಿದೀನಿ, G ಅಲ್ಲಿ ಹೇಳಿದೀನಿ. Annexure G may kindly be taken, madam. ಮಾನ್ಯರೇ, ಮೊದಲನೇದಾಗಿ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯತಾ
ಅವುಗಳು ಸರ್ವೆ ನಂಬರ್ 2/33ಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹದ್ದುಬಸ್ತು ಸರ್ವೆ ಕಾರ್ಯಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದೇವೆ. ಇದನ್ನು ಪರಿಗಣಿಸಿ ಕಾನೂನುಬದ್ಧವಾಗಿ ಕ್ರಮಬದ್ಧವಾಗಿ ಸರ್ವೆ ನಂಬರ್ 1 ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 2/33ರ ಹದ್ದುಬಸ್ತು ಸರ್ವೆ ಕಾರ್ಯ ನಡೆಸಿ ನಂತರ
ವರದಿ ನೀಡ
ತಮ್ಮ ವರದಿ ನೀಡಬೇಕು.
ಇದರಲ್ಲಿ ಎರಡು ಅಬಟ್ಟಿಂಗ್ ಲ್ಯಾಂಡ್ಸ್, ಸರ್ವೆ ನಂಬರ್ 1 and ಸರ್ವೆ ನಂಬರ್ 2/33. ಸರ್ವೆ ನಂಬರ್ 2/33, 3.49 acres is claimed by us. It is a land which is inherited by my father, by me from my father. ಈಗ their claim is that ಸರ್ವೆ ನಂಬರ್ 1 ನಾವು encroach ಮಾಡಿದೀವಿ ಅಂತ. Now we say that no, we are in possession of ಸರ್ವೆ ನಂಬರ್ 2/33 ಅಂತ. But whatever be the contention, my lord, survey notice under section 69 read with 37, my lord. 67 and 39 without holding any formal inquiry.
The said notice, they were supposed to appear on 13/2/2024 at 3 PM.
Our only contention is that let there be an inquiry. Yeah, no opportunity of hearing has been given.
Learned HCDP takes notice for all the respondents. Learned counsel for petitioners is directed to serve a copy of the petition along with annexures on the learned HCDP. Full stop. Next para. Learned counsel for the petitioner submits that although this writ petition was filed on 19th of February 2024, raising a challenge to the impugned notice
Annexure A.
at Annexure A dated 29/1/2024, nevertheless, on the strength of the said notice, the respondents have proceeded to fence a portion of the property
1.5 acres of the property.
measuring
1.5 acres.
1 acre and
1 acres, 1.5 acres, man. 1 acre 20 ಗುಂಟೆ.
1 acre and 20 guntas.
1.50 acre ಅಂತ ಹೇಳ್ತಾರೆ ನೋಟಿಸ್. 1.50 acre ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು 1.5 ಅಥವಾ 1.5
1.05 ಅಂತ ಬರೆದಿದ್ರ
ಇಲ್ಲ 1.50 ಅಂತ ಇದೆ. ಸೊ annexure A ಅಲ್ಲಿ
ನಿಮ್ಮ ಪೆಟಿಷನ್ ಅಲ್ಲಿ you have said 1.05.
ಅಲ್ಲ ಇಲ್ಲಿ
paragraph number 2.
ಇಲ್ಲ annexure A ಅಲ್ಲಿ 1.50 ಅಂತ.
Allah, that is with regard to survey number 1, whereas they are landholders of survey number 2/33, our RTC ಪ್ರಕಾರ.
Annexure A notice, impugned notice ಅಲ್ಲಿ 1.50 ಅಂತ ಕ್ಲಿಯರ್
It's not their land. Annexure B,
ಸರ್ವೆ ನಂಬರ್ 2/33 ಅಲ್ಲಿ
is ours.
ನಿಮ್ದು ಎಷ್ಟು ಜಾಗ?
ಅದ್ರಲ್ಲಿ 3.49 acres. 3.49 acres.
as per the RTC, Annexure B, page 21. They have encroached this land which is abutting to their land. ಅದನ್ನ ನಾವು ಪೊಸಿಷನ್ ತಗೊಂಡಿದೀವಿ.
ಆಯ್ತು. ಏನ್ ಹೇಳಿದೆ? Fence a portion of the property belonging to the petitioners measuring 1.50 acres. Full stop. The learned counsel would therefore submit that necessary application will have to be filed seeking amendment of the writ petition. Full stop. A week's time is granted to do the needful. Yes.
Petitioners. Lord, the petitioners are sons of one Mahadevu. My lords, the said Mahadevu filed an application for regularization of his occupation, my lords, in the year 1991. My lords, the said application is not considered.
50. 92. Form 50, madam. 91.
Form 50, my lords.
Form 50.
91, my lords.
So same orders, ಯಾವ್ದು? Same orders.
Great.
Yes.
Land bearing survey number 2, measuring 5 acres 6 guntas, was the subject matter of the position in favor of the petitioner society. The preliminary notification dated 23/8/1988, followed by final notification dated 25/9/1989. Possession was taken. An award was passed on 23/6/1990 in favor of the owner of the property, H.A. Subrao. Then the possession was taken on 14/10/1992. Pursuant to the possession taken, MR number 1 of 93/94 was certified in the name of the petitioner to an extent of 120 acres, including this land in question. Then the respondent number 3 filed a writ petition number 28,585 of 1995 before this honorable court, questioning the notification issued by the authorities concerned, acquisition in the name of the petitioner society is concerned. That writ petition came to be dismissed on 12/4/1996, challenging the acquisition. Then a writ appeal was filed by the respondent number 3 was also dismissed on 3/12/1996. One set of battle has been completed so far as the third respondent is concerned. The matter was pending before the land tribunal for grant of occupancy rights in favor of the respondent number 3 as well as Subbarao is concerned. Land tribunal granted occupancy rights in favor of the respondent number 3 on 3/5/1997. By that time, acquisition was completed, award was passed, possession was taken, acquisition was challenged by the respondent number 3 before this honorable court. This fact was suppressed by the respondent number 3. Then you last my kindly see the SLP was filed challenging the order passed by
The notification was issued in the name of
in the name of H.A. Subbarao as a Khatedar,
the owner.
and the respondent number 3 as a person in possession. Both the names have been
He claimed to be a tenant.
claimed to be a tenant. There is no dispute about it. Then the land tribunal granted occupancy rates on 3/5/1997.
97.
By the time the writ petition, writ appeal were dismissed by this court. Then an SLP was filed suppressing this
The
fact.
petitions were filed by the same respondent.
Respondent number 3. An SLP was filed before the apex court. It was dismissed on 23/7/1997.
What was the claim? If he had filed the writ petition,
He has filed the writ
what was
petition.
his claim?
His claim was he was the owner of the property.
Owner of the
He
property.
did not disclose about the pendency of the writ claim of occupancy rights. Then the landlord filed a writ petition questioning the order of the land tribunal before this court. This court dismissed the writ petition filed by the landlord on 23/5/2009. Then the writ appeal was filed by the landowner. Writ appeal number 2152 of 2009. Suppressing the fact which was concluded by the honorable court, confirmed by the apex court. There was a mutual settlement between the landlord and the tenant in the writ appeal before this honorable court by giving and taking certain portion of the property. This court did not doubted the conduct of the parties, accepted the compromise petition. It disposed of 3 acres to the tenant, 1 acre and half kunta, 1 acre 20 kuntas to the landlord is concerned. Then I was not a party to the separate proceedings. I came to know about the said proceeding, then I questioned the validity of a compromise petition by filing a writ petition number 16856 of 2004. Notice has been ordered to the landlord as well as the tenant by the respondent number 3 is concerned. The writ petition is pending. Then what
They have gone and got the revenue entries.
no, I questioned the settlement arrived by playing a fraud upon the court
Right.
before this court.
That
writ
matter is pending consideration.
pending consideration. Then what the third respondent did is suppressing all these facts. Once again, he filed a writ petition 16,856 of 2004. Second time questioning the validity of the notification section 4161 of the act is concerned. Again, that writ petition also dismissed on 25/2/2014. Then the writ appeal filed 978 of 2014 was filed. That was also dismissed by this court, upholding the acquisition in favor of the petitioner society. Then respondent number 3, suppressing all these facts. He went to the resident commissioner saying that
Got the revenue entries changed now.
he not the change. He challenged the revenue entry made in the name of the petitioner society MR 1 of 1994, saying that pursuant to the order passed by the land tribunal or as a division bench of the division bench order,
Entries change ಮಾಡಿದ್ದಾರೆ.
entries
That is
ಮಾಡಿ
your
ಅಂತ ಹೇಳಿ appeal ಹಾಕಿದ್ರು. Fortunately, no interim order was granted by the assistant commissioner. Notice was ordered to us. We entered appearance. We brought to the notice of the assistant commissioner, narrating all these producing all the 40 documents have been placed before the assistant commissioner. And written arguments also filed. On one fine day, you last may kindly see the proceeding of the assistant commissioner. page 314. On 13/2/2024, an application came to be filed on section 151 of CPC. Calling upon me to produce certain document. Kindly see application filed, annexure U, page 306. As if he does not know anything, Anta. Kindly see the application filed. What is the relevance of these documents where revenue entries before the Assistant Commissioner?
The appellant in the above case most pleased to direct respondent number 2 society to produce the below mentioned documents.
ಇವೆಲ್ಲ ಏನಕ್ಕೆ ಬೇಕು ಅದಕ್ಕೆ? Revenue records. I oppose the application.
Yes.
Assistant Commissioner, without hearing me and without calling upon for objection, he straight away ordered I should produce the document. Why should I produce?
So you are agreed of that order?
Please, page 314, dated 13/2/24. The Assistant Commissioner not even a courtesy to record the application.
Directed to furnish the document.
Directed to furnish the document. Kindly see the nature of documents sought for. In view of the nature of the dispute between the parties, absolutely not necessary at all. Whether the entries are necessary or not is the only
All these
question.
documents were references made in their objections. Therefore, we have sought for the production of the.
How can
But a
you
part
call
of the
upon them to submit the documents, sir?
Not because he has mentioned.
Only revenue transactions.
Okay.
It is not a suit.
Opportunity has to be
Then-
given to him to file the.
If you are to,
Let
if
us-
you have to succeed, you have to succeed on your own strength.
Because my lord, he has
Not
mentioned,
by calling the other side to
he
produce.
has mentioned all those references, my lord, that is the reason we
These
have.
are all
sought-
not matters
I have produced 40
considered in
documents.
this manner.
ನಾನು ಏನ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್
Commissioner cannot go into all these aspects.
Since he has, my lord, made reference, that is what the Assistant Commissioner did, my lord. That's the
What do you say now?
opportunity.
What do you want now?
The opportunity may be given to
Not
file
necessary at all.
objections.
No,
Alla,
no.
my request before this
I'm
Honorable Court
sorry.
is, we have filed an application, my lord. There, the contention of the petitioner is that the opportunity is not given for filing objections. That opportunity may be given.
My
That is
objection
my-
is not necessary at all, not the
Yes.
objections. Why should I produce this document? You are a party to the proceeding, twice went to the Supreme Court, all the proceedings have been failed. And it is arm twisting proceeding before the Assistant Commissioner. Absolutely, even the Assistant Commissioner cannot entertain the appeal at all. In a view of facts of like this nature. It is nothing but reopening an issue again.
Purple. No, now since you have come only on this
this
order passed on the IA.
Yes, please.
We will say something about that one and dispose of the matter.
Please.
Learned AGA takes notice for response number 1 and 2. Learned Counsel Shri B. Vijay Shetty
Yes.
has entered appearance for response number 3. Next para. The petitioner, House Building Cooperative Society, is before this court aggrieved of an interim order dated 13/2/2024 passed by the second respondent Assistant Commissioner, Bangalore South Subdivision. Full stop. Next para. The third respondent appears to have filed an appeal under section 136(2) of the Karnataka Land Revenue Act of 1964. Challenging the mutation entries made in favor of the petitioner society. Full stop. It is not disputed that the name of the petitioner society has been entered in the land records consequent to the acquisition notifications issued by the state government and the land being acquired for the benefit of the petitioner society. Full stop. It is the contention of the petitioner society that earlier too, the third respondent, claiming to be the owner of the land in question, had challenged the acquisition notifications. but failed.
On two occasions.
ಒಂದ್ಸರಿ ಅಲ್ವಾ?
ಎರಡ್ ಸರಿ ಹಾಕಿದ್ರು. ಎರಡ್ ಸರಿ ಹಾಕಿ ಎರಡ್ ಸರಿ ಫೇಲ್ ಆಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಗಿ ಎರಡ್ ಸರಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ಎರಡ್ ಸರಿ ಹಾಕಿದ್ರು.
On two earlier occasions.
ಹೌದು.
But he failed on both the occasions, right up to the Honorable Supreme Court. Full stop. Now, however, on the strength of an order said to have been passed by the Land Tribunal, Bangalore South Taluk on
3/5/1997.
3/5/1997. The third respondent is seeking to set aside the revenue entries made in favor of the petitioner and to enter the name of the third respondent on the basis of the orders said to have been passed by the Land Tribunal. Full stop. Nevertheless, the writ petition has been filed in respect of the impugned order passed by the Assistant Commissioner on an application filed by the third respondent under section 151 of the Code of Civil Procedure, seeking a direction to the petitioners herein to furnish the documents listed therein. Full stop. There are about 25 documents which the third respondent is seeking to be produced by the petitioner society. Full stop. Learned counsel submits, learned counsel for the petitioner submits that although objections have been filed to the said application,
Objections are not filed. It's not for time to file objections.
although the petitioner society sought for filing objections to the application, ಅಲ್ಲಿ 4/1/2024 ಅಲ್ಲಿ
ಹೌದು.
respond about two filed objections
Objection.
along with documents
Objection to the appeal memo
Main-
along
main.
with documents, written arguments.
and also
Main appeal.
main
To the appeal memo with the documents and written arguments.
when was this application filed?
13-2. ಅದು ರೆಕಾರ್ಡೇ ಮಾಡ್ಲಿಲ್ಲ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
13/2.
ಹೌದು, 13-2 ನಲ್ಲಿ ಕೋರ್ಟ್ ಡಿಡ್ ನಾಟ್ ರೆಕಾರ್ಡೆಡ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ ಅಟ್ ಆಲ್. Directed me to produce the document.
ಏನಲ್ಲ learned counsel for the petitioner submits that the application is said to have been filed on 13/2/2024 and on the same day the impugned order has been passed by the Assistant Commissioner directing the petitioner society to furnish the documents. Full stop. Next para. Learned counsel for the contesting respondents fairly submits that if the petitioner society seeks to file objections to the application,
Is not necessary. That is what I wanted to continue.
our submission, an opportunity may be given to the petitioner society to file objections, and thereafter the Assistant Commissioner may pass necessary orders. Full stop. Next para. For contra, learned counsel for the petitioner submits that such an application cannot be entertained by the Assistant Commissioner, having regard to the fact that the procedures before the authority are only summary procedures, and such an application cannot be entertained by the revenue authorities. Full stop. Next para. In the considered opinion of this court, the petitioner society should have been given an opportunity to file objections, and thereafter, the Assistant Commissioner may pass necessary orders on the application filed by the third respondent here. Full stop. Next para. Consequently, the writ petition is allowed while setting aside the impugned order dated 13/2/2024 passed by the Assistant Commissioner in RA bar SOU dash 596 of 2023 on the IA dated 13/2/2024 filed by the third respondent here. Full stop. Next para. The petitioner society shall be given an opportunity to file objections.
ಬೇಕಾಗಿಲ್ಲ ಇವು ಅಂತ.
Alla, you say so in your objections, please. To file objections and raise all contentions, including the fact that such an application cannot be entertained by the authority. Full stop. The Assistant Commissioner shall consider the objections to be filed by the petitioner society, hear the parties, and thereafter pass necessary orders. Ordered accordingly. Please.
Petitioner purchased this property, not scheduled property, through a registered sale deed. Annexure B, the registered sale deed. Or his vendor had earlier purchased it through annexure.
1989.
Yes,
You purchased in the year 1989 or
no,
2016?
my vendor, man. My
You
vendor
purchased in 2016.
Yes,
Ah,
yes. Ma'am. Now, my lord, thereafter, my lord, my vendor's name was there in the revenue records, RTC and all that. I have produced that. My lord, portions, adjacent lands, not this land, my lord, was sought to be acquired for
KHP.
KHP. My lord, that were all challenged. We are not parties, our lands were not acquired. My lord, that was writ petitions were allowed, writ appeals were also quashed, and therefore DC has said, my lord, you enter the original owner's names in the revenue records, because that has become final. Taking advantage of that, my lord, original owners, their vendors, my vendor's vendor, one Rangappa and 4 joint owners were there. Their names came to be entered in 2000 in the RTC. I did not know at all.
When it was entered?
My lord, it was, my lord, I have produced it. My lord, 2000 last year. Last year. My lord, kindly see annexure F.
6/2/2024.
No, that is
2/2024, order of the Tahsildar to enter the names of the LRs of the original.
original owners.
in the
First in
Khata
2023, they entered the original vendors. Original
You are
owners.
challenging the order of the Tahsildar.
But now, my lord, to enter their LR's name, my lord,
Go before the Assistant Committee.
I have, my lord, he says, my lord, I have not produced any documents and therefore apparent fraud.
Huh?
Currently,
No, sir.
when
The provision is very clear. 136(2). You will have to go before the Assistant Commissioner.
but original vendor's name, they were not living at all.
Sir,
That
you will
is-
have to challenge it before the Assistant Commissioner. And there is a provision for revision also before the Deputy Commissioner.
But he is intending to sell, alienate the properties and all.
Huh?
Taking advantage of these things, my lord, they are.
No, sir. You will
On
have
the
to go
face
before
of
the-
it, my lord, what the Tahsildar says is, my lord, that I have not produced any registered documents to show that they have.
You can't go into all that. There's a alternative efficacious remedy available for you. You go before the Assistant Commissioner. Berkeley.
My lord, can I, my lord, make this request? Not, he is intending to sell, that's what I am to, that's why urgent. But till then, my lord, for some brief period, my lord, to stay this order. Impugned order,
Agodilla.
so that, my lord, I will be
Sir, coming
protected.
before this court, you could have gone before the Assistant Commissioner.
I now having come, my lord, some small protection, my lord, for 10-15 days. I will go before the Assistant Commissioner as per your order. But till then, my lord, let him not create third party interest. That's all I am.
Sir, it will not be only because the entries are made in the revenue records. There are, there's a registered document in your
That's,
favor. then how can we
only
sell
on
the
that
property?
basis I will go. I am claiming only on that.
They cannot sell the property, sir. And that the sale bid will have no value. Encumbrance certificate are nodal.
That will be my case. That will be my, but still, my lord, for a 10-15 days, my lord, if this order operation is
No,
stayed,
sir.
and if I am permitted, directed to go there,
No.
that will serve the purpose. Otherwise, my lord, unnecessarily, my lord, again, some third party's interest and all that, my lord. Then I will have to-
Anyway, everything is ready. The same thing you go and file before the assistant commissioner tomorrow itself.
There, my lord, to get it listed, everything, how your lords, these are deliberately, these things are done. That is why, my lord, we will not be
Sir,
able to
your
get
contention that he will sell away the property cannot be accepted, sir.
that they have made preparation. That is how, my
How
lord,
can they sell it? Encumbrance certificate ಅಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರಿಲ್ವಾ? Is it only on the basis of revenue entries?
once RTC is there, they will register it.
No, no. What do you want?
I've taken order.
Learned
For
AGA takes notice for response number 1 to 4.
1 to 4.
Notice to response number 5 to 11 is
yes.
not necessary for the following reasons. Next para. Learned AGA has raised a preliminary objection that the petitioner is seeking to raise a challenge
Not only that, my lord, I have
to an
sought for
order
a
passed by the fourth
Mandamus
respondent,
also, my lord, to
Special
enter.
Tahsildar, Yelanka Taluk,
Dated 6/2/2024.
at annexure L, dated 6/2/2024. Full stop. Learned AGA submits that on going through the impugned order, it is clear that the petitioner herein contested the matter before the Special Tahsildar in the matter of revenue entries in respect of 4 acres and 13 guntas of land in survey number 54 of Allala Sandra village, Yalanka Hobli, Yalanka Taluk, Yalanka Taluka.
Yalanka Taluk ಅಂತ ಹಾಕಿದ್ದಾರೆ. Yes.
All right.
Yes.
Full stop. The order passed by the Special Tahsildar is in terms of sections 128 and 129 of the Karnataka Land Revenue Act of 1964. Full stop. There is an express provision contained in section 136(2) of the Act empowering the Assistant Commissioner to consider an appeal in respect of any orders passed by the Special Tahsildar under sections 128 and 129 of the Act. Full stop. The learned AGA would therefore submit that when there is an alternative efficacious remedy available to the petitioner, the petition cannot be entertained. Full stop. Next para. ಏನ್ Mandamus ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
Pardon me.
ಏನ್ Mandamus ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
But to enter my name, revenue.
Enter your name.
Yes.
In the RTC.
RTC and
Revenue record.
in respect, following the registered sale deed.
Your name was not entered.
No, I have been requesting, my lord, the
Learned counsel for the petitioner, on the other hand, seeks to contend that a claim is also made by the petitioner to enter his name in the RTC on the strength of a registered sale deed dated 1/2/2016. Full stop. It is contended that the name of the petitioner's vendor, K. Sugunamurti, Sugnanamurti, is entered in the RTC on the basis of a registered sale deed dated 19/12/1989.
Yes.
Full stop. Next para. Having heard the learned counsel for the petitioner and the learned AGA, this court is of the considered opinion that the contentions of the learned AGA is required to be sustained. Full stop. If an order has been passed by the Tahsildar in terms of section 128 or 129 of the Act, the statute provides for an efficacious remedy by way of an appeal before the Assistant Commissioner under section 136 bracket 2 of the Act. Full stop. Therefore, the petitioner is required to approach the Assistant Commissioner. Full stop. Next para. Accordingly, the writ petition stands dismissed, granting liberty to the petitioner to approach the Assistant Commissioner. Yes.
Order. Some direction order for the assistant committee to consider the appeal may order.
Direction.
Otherwise they will not act at all. That is the whole problem. That's why we have been troubling your urges. They will deliberately, they will not do it. That is the whole problem. These things are not that they don't know it. Sometime.
You are not even filed an appeal.
I will, if appeal is filed.
Maadi.
But if appeal is filed, my lord.
If an appeal is filed by the petitioner and interim order of stay, stay and parallel.
Stay, let the appeal itself be.
Stay of what?
Impugned order. The order of Tahsildar.
Stay of the revenue entry. If the petitioner files an appeal and seeks interim relief, seeking stay of the orders passed by the special Tahsildar, the Assistant Commissioner shall consider the same and pass necessary orders having regard to the predicament of the petitioner that the contesting respondent may alienate the property during the pendency of the appeal. Yes.
Okay.
Kindly pass over, my lord. Serial number 10, my lord. Kindly pass. Serial number 10. Kindly pass over.
Pass over.
Appear for the petitioner. My lord, petitioner is seeking.
Very attacks is right. Yes.
May submit, my lord. The petitioner is seeking a review of this court's order dated 30th January 2024, my lord. On the ground that there are some mistakes I have kept in. On factual aspects, the petitioner therein had not brought to the notice of this honorable court several aspects. These are, my lord. This is in respect of one land bearing survey number 344, my lord. Now, for instance, only one instance, kindly see paragraph 2 of my lord's order. In this, a learned counsel for the petitioner seeks to contend that it is not disputed by respondent number 6, that is me, that the petitioner as well as respondent number 6 are in possession of two pieces of property which are adjacent to each other. This itself is not correct. My lord, however, the contention of the petitioner is that in terms of the orders passed by the land tribunal, 92 cents in survey number 344/1 of so and so village was granted to Guru Raj Upadhyaya. It is not correct, my lord. He is the owner of the land. My lord, the facts are these. And it is the entire extent of 344/1, my lord, which had fallen to the share of the petitioner therein is 46 cents. My lord, annexure C, if for a minute may kindly be seen.
Learned AGA takes notice for response number 1 to 5.
1 to 5.
Allah, 2 to 6. The petitioner is permitted to serve a copy of the review petition on learned counsel Shri
Mr.
Anand Shetty,
Adit Anand Shetty.
who appeared for
The
respond number 1 in the writ petition.
Yes,
Full stop. Release this matter on 13th of March.
my lord, may I request for an interim order of stay for this reason, my lord? Only.
No, not at this stage, sir.
Allah, only for.
We have
this
only
reason.
directed that you should go
Allah.
before the
Yes,
civil court.
yes, civil court, my lord, there is a suit filed by the petitioner.
Not at this stage,
And-
not in
and-
a review petition.
Allah, a suit ಅಲ್ಲಿ, that
Or
suit.
early, let them come. We have given a date for the next week. You please come, let him come, we'll see. A week's time is granted for complaints of office objection. A week's time, same order.
I represent respond number 5 in this
case, for petitioner lodge. The office protection in page number,
An office objection,
the, along with compromise petition, the annexed the. page-
better
in
copy of
page-
annexure C,
in page number eight.
better copy of annexure C.
ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಇದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಸ್ಕೆಚ್ ಒಂದು ಇನ್ ಪೇಜ್ ನಂಬರ್ 88 to
All
96, that is not visible ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, that is, I am not rely on that.
office objection is overruled.
Please.
I may be permitted to produce the same
ಏನು?
sketch along with the compromise petition.
ನೀವು ಕೊಡ್ತಾ ಇದೀರಾ?
ಕೊಡ್ತೀನಿ.
ಕೊಡಿ. ಅದು ತೆಗ್ದಾಕ್ ಬಿಡಿ. Having regard to the office objections, that a better copy of annexure C should be filed, comma, learned counsel for the contesting respondent number 5 has filed a memo along with list of documents, along with the certain documents. Full stop. Learned counsel submits that annexure C, which is the
ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್.
compromise petition or compromise decree na?
ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್
Compromise petition,
annexed to sketch in page number 88 to 96.
Sketch annexed to the compromise petition.
compromise petition na,
ಹೌದು ಸರ್.
Compromise petition ಗೆ ಒಂದು sketch annex ಮಾಡಿದ್ರು.
which is a compromise petition containing certain sketches have also been furnished along with the memo. Full stop. In that view of the matter, office objections are overruled. Yes.
In this case, Lordship, I will challenge the order passed by the Deputy Commissioner as per annexure, please, Lordship, annexure G. Sorry, annexure H, please, Lordship.
This is under 136,
136, please, Lordship.
136(3).
3.
Who had approached the assistant commissioner?
The fifth respondent was approached, the first assistant commissioner approached by the fifth respondent,
Challenging,
challenging the mutation entry affected as per the compromise decree, please, Lordship. The
yavaga?
basis of the
MR number,
MR number
MRS
55/2018-2019.
1819.
1819, he has filed the petition on 22.
2022.
Please, Lordship.
Ah,
That Tahsildar was rejected, dismissed the appeal. And-
AC.
AC.
AC
I am sorry,
dismissed-
the AC is dismissed
Dismiss the appeal. Ah,
And they approached the assistant commissioner filing the revision.
hmm.
In that revision, the deputy commissioner was allowed and remand back, set aside the MR number 55/2018.
On what ground?
It is referred in the in page number 256, please, Lordship.
Yes.
The paras 5 in the comments ಆಗುತ್ತೆ.
Yes.
ಅಪೀಲುದಾರರು ನನ್ನ ಮುಂದೆ OS 66/36/2018 ಪಕ್ಷಕಾರರು ಸಲ್ಲಿಸಿದ ರಾಜಿ ಅರ್ಜಿಯ ನಕಲನ್ನು ಮತ್ತು ಸದರಿ ದಾವಾದ ದಿನಚರಿ ಆದೇಶ ಪ್ರತಿಯನ್ನು ಮಾತ್ರ ಹಾಜರುಪಡಿಸಿದರು. ಸದರಿ ರಾಜಿ ಅರ್ಜಿಯ ಆಧಾರದಲ್ಲಿ ಜಾರಿಗೊಂಡಿರುವ ಅಂತಿಮ ಡಿಕ್ರಿಯ ನಕಲನ್ನು ಅಪೀಲುದಾರರು ಹಾಜರಿಸಿರುವ ರಾಜಿ ಅರ್ಜಿಯ ನಕಲಿನಲ್ಲಿ ಕಂಡುಬಂದಿರುವಂತೆ ಎ ತಪಸೀಲು ಸ್ವತ್ತನ್ನು ಅಪೀಲುದಾರರಿಗೂ ಬಿ ತಪಸೀಲು ಸ್ವತ್ತನ್ನು ಪ್ರತಿವಾದಿಗಳಿಗೂ ರಾಜಿ ಒಪ್ಪಂದದಂತೆ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿದೆ. ಅದರಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ಸರ್ವೆ ನಂಬರ್ 101/3ರಲ್ಲಿ 2 ಎಕರೆ 12 ಗುಂಟೆ ಅಪೀಲುದಾರರಿಗೆ, ಅದೇ ಸರ್ವೆ ನಂಬರ್ ನಲ್ಲಿ 2 ಎಕರೆ 8 ಗುಂಟೆ ಪ್ರತಿವಾದಿಗಳಿಗೆ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿದೆ.
Your contention is there was a
Party,
compromise decree passed by the civil court,
please.
Yes.
but you are not furnished a copy of the decree.
Yes, I have produced.
Huh?
I have produced. The decree was duly executed by the trial court also, Lordship.
Where is that
The decree is registered decree I have produced before this honorable court, your Lordship, in page number 99. It is registered duly on the stamp paper and that was registered before the sub-registrar office. I have produced both the document before the court below, but the deputy commissioner has ignored that document what I have produced.
ಅಲ್ಲ, ಇವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಬರೆದಿರೋದು. ಇವ್ರು ತಾನ ಅಪೀಲ್ದಾರರು.
ಹೌದೌದು.
ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಆಯ್ತು, ಆಮೇಲೆ
ಅಪೀಲುದಾರರ ಪ್ರಕಾರ ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದ ರಾಜಿ ಅರ್ಜಿಯ ಜೊತೆಯಲ್ಲಿ ಒಂದು ನಕ್ಷೆ ಆಧರಿಸಿದ್ದು, ಅದರ ಪ್ರಕಾರ 2 ಎಕರೆ 8 ಗುಂಟೆ ಜಮೀನು ಪ್ರತಿವಾದಿಗೆ ಹಂಚಿಕೆ ಆಗಿಲ್ಲದೆ ಕೇವಲ 1 ಎಕರೆ 16 ಗುಂಟೆ ಮಾತ್ರ ಹಂಚಿಕೆ ಆಗಿದ್ದರಿಂದ MR 55/2018-19 ಮುಟೇಶನ್ ಎಂಟ್ರಿಯನ್ನು ರದ್ದುಪಡಿಸಲು ಅಥವಾ ತಿದ್ದುಪಡಿ ಮಾಡಲು ಅವಕಾಶವಿದೆ. ಆದರೆ ಅಪೀಲುದಾರರು ಉಲ್ಲೇಖಿಸಿರುವ ಸದರಿ ನಕ್ಷೆಯನ್ನು ಅಂತಿಮ ಡಿಕ್ರಿಯ ಭಾಗವನ್ನಾಗಿ ಅನುಮತಿಸದೆ ಅಥವಾ ಇಲ್ಲವೇ ಎಂಬುದು ಸ್ಪಷ್ಟಪಡಿಸಿ ಜಾರಿಗೊಂಡಿರುವ ಅಂತಿಮ ಡಿಕ್ರಿ ದೃಢೀಕರಣ ನಕಲನ್ನು
not correct according to you.
please
Take the court to the appropriate page in the compromise decree.
compromise decree, your honor, it is property allotted to me in page number 68, please, Lordship.
ಅಲ್ಲ, compromise ಅಲ್ಲ, final decree ಅಲ್ಲಿ.
Final decree.
Final decree ಅಲ್ಲಿ.
In the final decree, please, Lordship.
Page 68 of the decree, 170.
179,
179.
item number
21, please, Lordship. ಅದರಲ್ಲಿ 2 ಎಕರೆ 8 ಗುಂಟೆ ಇದೆ. There is no ಖರಾಬ್ or what is that?
179.
Item number 21.
2
acres 8 guntas of Devanagundi village, Anagondana Obli, Vaskote Taluk.
So ಇಷ್ಟಕ್ಕೇನೆ revenue entry ಮಾಡ್ಬೋದು.
Revenue entry ಆಗಿದೆ, ನನ್ನ ಪ್ರಕಾರ mutation ಆಯ್ತು.
Yes, what is the difficulty?
My humble submission before this, annexed to the compromise petition, we have given sketch. Now, what is the inland and what is the Arab land to be?
There is a compromise decree.
Please.
That is why I am not going into the compromise petition.
Please.
If according to you, there is some mistake in the compromise final decree, then you will have to get it corrected.
No, in the final decree.
Without getting it corrected,
No, there is no need to correct the final decree.
ಅವ್ರು ಓದಿದ್ರಲ್ಲ, page number 179.
This is item number 21 is survey number 101/3. Bar 3, measuring 2 acres 8 guntas. And my property, I have been allotted in the same survey number. It is also available on record.
2 acres 12.
2 acres 12 guntas. At serial number 14 of
item number 14,
item number 14.
Item number 14,
Item number 14 of the compromise petition that they have filed.
ಇದು ಫೈನಲ್ ಡಿಕ್ರಿ ಐಟಮ್ ನಂಬರ್ 18, ಪ್ಲೀಸ್. 18 ಅಲ್ಲಿ ಅವ್ರ ಟೋಟಲ್ ಮೆಷರ್ಮೆಂಟ್ 4 acre 20.
ಅಲ್ಲ, ಸರ್ವೆ ನಂಬರ್ ಬೇರೆ ಅದು.
ಅಲ್ಲ, the dispute is with
This is regarding survey number 101/3.
Correct.
ಎಲ್ಲಿದೆ ನಿಮ್ದು 101/3?
18, item number 18, page number 199.
Huh?
Page number 199.
Item number 18 is at page number 176. 176 ಅಲ್ವೇನ್ರಿ? ಇದು 179 ಆದ್ರೆ ಐಟಮ್ ನಂಬರ್ 21
ನಮ್ಮದ್ರಲ್ಲಿ
18, page number, page number 199, item number 18 is allotted to the respond number 5.
18 80 18 18 is at ಆಯ್ತು. That pertains to survey number 94/4.
ಇಲ್ಲ, item number 18 is 101/3.
103.
ಹೆಂಗ್ರಿ 2 ಸರಿ ಬರುತ್ತೆ ಐಟಮ್ ನಂಬರ್
ಇಲ್ಲ, ಒಂದು ಜಮೀನಲ್ಲಿ ಇಬ್ಬರಿಗೂ ಪಾರ್ಟಿಷನ್ ಮಾಡಿರೋದು ಸರ್.
ಅದಲ್ಲ,
Page number 199.
ಪೇಜ್ ನಂಬರ್ 179 ಅಲ್ಲಿ ವಾಟ್ ಈ ಪಾಯಿಂಟೆಡ್ ಔಟ್ ಐಟಮ್ ನಂಬರ್ 21 ಇದೆ.
21 is.
ಐಟಮ್ ನಂಬರ್ 18 ಅಂತ ಅದಕ್ಕೆ ಮುಂಚೆ ಬರಬೇಕು
ನಮ್ಮ ಐಟಮ್ ಅಲ್ಲಿ ಸರ್, ನಮ್ಮದು
ಅಲ್ವಾ?
ನಮ್ ಶೆಡ್ಯೂಲ್ಗುನು
ಆಯ್ತು, ಯಾವ ಪೇಜ್ ನಂಬರ್?
ಈ ಶೆಡ್ಯೂಲ್ಗೆ you last kindly
ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ. 199.
Page number 199.
199.
In page 96 of the decree.
199.
ಹೌದು.
Page number 18, item number 18, yes. 101/3, 4 acres 20 guಂಟಾಸ್.
ಅದು ಫುಲ್ ಮೆಷರ್ಮೆಂಟ್ ತೋರಿಸಿದ್ದಾರೆ ಸರ್.
ಇಲ್ಲ ಇಲ್ಲ ನಮ್ಮದ್ರಲ್ಲಿ ಇದೆ.
4 acre 20 guಂಟಾಸ್ ಇದೆ. 4 acre 20 guಂಟಾಸ್ is the full measurement.
ನಮ್ಮದು ಎಷ್ಟು ಬಂತು ಅಂತ ಹೇಳಿ
ಅವರಿಗೆ
ಯಾವ ತರ ಬರ್ಸಿದ್ರಿ ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ?
ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಪ್ರಕಾರ ಸ್ವಾಮಿ 2 ಎಕರೆ 8 ಗುಂಟೆ ನನಗೆ, 2 ಎಕರೆ 12 ಗುಂಟೆ ಅವರಿಗೆ, ಅವರೇ ಕಾಂಪ್ರಮೈಸ್ ಬರ್ಸಿದ್ದಾರೆ.
So this is a mistake.
This is the mistake where the Karab land is excluded
The dispute
and
is
only Ain land has been mutated in the name of the petitioner herein. Ain land is has to be divided to
Allah.
both the.
ಅದೆಲ್ಲ ನಾವಾಗ್ಲಿ ರೆವಿನ್ಯೂ ಅಥಾರಿಟೀಸ್ ಆಗ್ಲಿ ಕೆನಾಟ್ ಗೋಯಿಂಗ್ ಟು. If there is some mistake in the decree, you will have to get it corrected.
Please, my lord, there is no mistake in the decree.
ಅದ ಹೆಂಗಾಗುತ್ತೆ? 4 acres 20 guಂಟಾಸ್ ಇಲ್ಲಿ item number
20
18
guಂಟಾಸ್ ಅಲ್ಲಿ your lordship kindly I have produced
If
the.
the total extent of land is 4 acres 20 guಂಟಾಸ್,
Please.
how have you divided it?
2 acre 12 guంటాస్, 2 acre 8
2 acre 8 guಂಟಾಸ್.
ಮತ್ತೆ how can you show item number 18 as 4 acres 20 guಂಟಾಸ್?
The dispute is not with regard to that measurement.
I have produced the plain copy, Your Honor. In that plain copy, the total measuring is 4 acre 20 guంటాస్ is there. There is no Karab land.
Dispute is with regard to the Karab land.
Anyway, see, there is a mistake in the final decree. Please not.
ಅಲ್ಲೇ Karab.
Now, if there is any other sketch showing how it has been divided.
Please, my lord.
Where
That
is
is
it?
annexed to the compromise petition.
Yes, where is it?
That I have produced today before this court.
Yes.
It is.
ಸ್ಕೆಚ್ಗೆ ಯಾವ್ದು ಸೈನ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಎಲ್ಲ
ಸೈನ್ ಆಗಿಲ್ಲ ಸ್ಕೆಚ್ಗೆ. ಪಾರ್ಟಿ ಸೈನ್ ಆಗಿಲ್ಲ ಸ್ಕೆಚ್.
Compromise petition ಜೊತೆ annexed ಅಂತ ಬರ್ದಿದೆ. Compromise petition ಅಲ್ಲೂ it is mentioned in the compromise petition also.
Page number 16, na?
Please.
Page number 60.
Page number 60, 59.
ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿದೆ.
SN Ratnamma. 2 acres 12 guంటాస్. 34 guంటాస్ Karab land. 1 acre 18 guంటాస్ is the Ain land. Ketchel.
Left side ಅಲ್ಲಿ block 1.
Block 1, my lord.
2 acres 12 guಂಟಾಸ್.
Please, man.
ಮತ್ತೆ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ SN Ratnamma.
Please, man.
1 acre 37 guಂಟಾಸ್.
ಹೌದು. Second block is Lakshman Reddy.
ಓ ಈ ಕಡೆದು 101/2.
ಹೌದು, ಅದು 101/2.
So 100/2.
101/.
We are only concerned with 101.
101/3.
ಯಾವ ತರ ಡಿವೈಡ್ ಮಾಡಿದ್ದಾರೆ?
1 acre 2 acre 12 guంటాಸ್.
ಕೆಳಗಡೆ ಭಾಗ block 2.
Oh, block 2 is belongs to Lakshman Reddy, that is petitioner herein.
2 acres 8 guಂಟಾಸ್.
Please, man.
ಅವ್ರದ್ದು 2 acres 12 ಗುಂಟಾಸ್.
ಅವ್ರದ್ದು 2 acres 8 ಗುಂಟಾಸ್. ನಮ್ದು 2 acres 12 ಗುಂಟಾಸ್.
2 acres 8 ಗುಂಟಾಸ್.
8 ಗುಂಟಾಸ್.
ನಿಮ್ದು 2 acres
12 ಗುಂಟಾಸ್. Out of which 34 guంటాస్ is the Karab.
ಅದಲ್ಲ, we can't go into all that. There is a sketch here
Please, madam.
which says, you have been given 2 acres 12 guntas.
2 acres 12
In
guntas.
terms of the sketch,
Please, madam.
that is how it has to be divided.
That's what, my lord.
Ah,
Our,
Well,
ನನಗೆ only 34 guntas has been allotted to us.
Huh?
Only 34 guntas has been mentioned in my MR and the entire extent is mentioned
My
to the.
humble submission, your lordship. In the plaint itself, there is no Karab as not mentioned in the plaint.
we are not concerned about the Karab now.
Yes, as per the,
That is why we are always insisting Lebanese sketch should be produced.
that
That
purpose.
will only show how you have intended to divide the property.
Please, lord.
Now, as per the sketch, it is clear that the northern portion is given to them, measuring 2 acres 12 guntas. Southern portion is given to you, measuring 2 acres 8 guntas.
Please, lordship.
According to that, only RTCs have to be entered.
According to that, the final decree was passed, 2 acres 8 guntas was allotted to me. And as per that, I approached the revenue authority and revenue authority has
2
motivated
acres
me.
8 guntas matra.
Please,
Ah.
lordship.
Ah.
And after lapse of 3-4 years, your honor,
What are you questioning then?
therefore questioned.
Bari 2 acres 8 guntas.
ಅವರು 2 acres 8 guntas ಮಾಡಿದ್ದಾರೆ, ನಮ್ಗೆ only 34 guntas ಮಾಡಿದ್ದಾರೆ.
How can you raise objection?
ಅಲ್ಲ, ನಾನು 34 ಗುಂಟಾಸ್ ಮಾಡೋದೇ ಇಲ್ಲ, ಉಳಿಕೆದ ಅವ್ರಿಗೆ ಬಿಟ್ಟಿದ್ದು ಸ್ವಾಮಿ. ನಾನು
What is
ಕೇಳೇ
the
ಇಲ್ಲ.
difficulty?
My lord, the revenue records before the your lordship, where only 34 guntas has been mentioned in the name of the respondent number 5 herein.
Why are you objecting?
I have challenged that.
I am not objecting. They have raised the objection. What will happen, lordship, after final decree proceedings, I approach the revenue authority.
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರೋದು ಬರೀ 2 acres 8 guntas ಅಲ್ವೇನ್ರಿ?
Including Karab.
ಅವೆಲ್ಲ ಬಿಟ್ಬಿಡಿ. 2 acres 8 guntas ಅವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿರೋದು.
Please, madam.
RTC ಅಲ್ಲಿ 2 acres 8 guntas ಇದೆ. How can you challenge it?
No, I am not challenging the extent what they have has been allotted to the petitioner herein.
Huh.
The land as per the compromise petition,
Yes.
what we have produced the sketch by mutual consent of the both the parties.
Yes.
The extent of the land, in land to the parties is for the Ratnamma is 1 acre 18 guntas and for them 1 acre 16 guntas. There cannot be 2 acres 8 guntas.
ನಿಮ್ಮ sketch ಅಲ್ಲಿ ಅವೆಲ್ಲ ಬಂದಿಲ್ಲ.
ಬಂದಿದೆ. That is reflected in the compromise
There is
petition.
a line drawn, northern portion Ratnamma, southern portion Lakshman Reddy.
Please, lord.
Please, my lord. In the compromise petition also it is mentioned.
Mentioned, there is no.
The annexed sketch, whatever it is.
ಅವ್ರಿಗೆ 2 acres 8 guntas ಇದೆ. In terms of the compromise decree.
As per the compromise decree, along with the Karab, 2 acres 8 guntas.
Correct.
ಆ ತರ
And
ಬರ್ದೇ
it
ಇಲ್ಲ.
is not mentioned as 2 acres 8 guntas, including Karab. Total land has been mentioned to the petitioner herein, 2 acres 8 guntas.
ಹಂಗಲ್ಲ ಬಡಕ್ ಬರೀದಿಲ್ರಿ, ಬೇರೆ RTC.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದು.
Page 248.
248.
Annexure F.
ಹಾ.
SN Ratnamma ಅವರಿಗೆ 26 ಗುಂಟೆ.
Inland ಪೂರ್ತಿ ಮಾಡಿಸ್ಕೊಂಬಿಟ್ಟಿದೆ.
SN Ratnamma, that is the respondent number 5 herein. Only 26 guntas has been mentioned in our name instead of 2 acres 12 guntas.
So you will have no objection if 2 acres and 12 guntas is shown to them?
I have no objection. My objection is, lordship, they have not mentioned the.
Order has been passed by the deputy commissioner.
Already,
my name is.
ನೀವು ಇಬ್ರು ಒಪ್ಕೊಂಡು ಹೇಳ್ಬೋದಾಗಿತ್ತಲ್ರಿ. Why are you fighting like this?
That is my
ಡೆಪ್ಟಿ ತಹಶೀಲ್ದಾರ್ ಅದನ್ನೇ ಮಾಡಿದ್ರು.
deputy commissioner.
You could have given a statement.
I have given.
In terms of the compromise decree, I am entitled for 2 acres 8 guntas ಅದನ್ನ ತೋರಿಸಿದ್ದಾರೆ. 2 acres 12 guntas ಅವ್ರ ಹೆಸರಲ್ಲಿ ತೋರಿಸ್ಬೇಕಂತ ತೋರಿಸಿ ಅಂತ ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
ಅಲ್ಲ, ಅವ್ರು ಅಪ್ರೋಚ್ ಮಾಡಿಲ್ಲ. First I have approached the Tahsildar and I have effected the mutation in 2018 itself. After lapse of 4 years.
He also cannot raise any objection. See, ನೀವು appeal file ಮಾಡೋದು ಯಾವ ತರ ಮಾಡಿದೀರಾ? Challenging the mutation entry made in his favor. ತಪ್ಪಲ್ವಾ ಅದು?
But no.
Why should you challenge the mutation entry made in their favor? If it is in terms of the compromise decree.
In terms of the compromise, if it is entered, we would have not objected for the entries.
ಹೌದು, 2 acres 8 ಗುಂಟಾನೆ ತೋರಿಸಿ.
2 acres 8 guntas along with the.
ಅವೆಲ್ಲ ಬೇರೆ ವಿಚಾರ ಇಲ್ಲ ಇಲ್ಲಿ. Total extent of land is 4 acres 20 guntas.
4 acres 20 guntas.
2 acres 8 guntas are shown to them.
Remaining 2 acres, 12 guntas had to be shown to you.
No,
Kharab land is there.
It
It would include Kharab land.
including Karab land ಅಂತ mention ಮಾಡಿಲ್ಲ ಅವರು.
2 acres, 12 guntas, including Kharab.
Karab land.
ಅವ್ರು
2 acres, 8
8
guntas, including Karab land.
ಅಷ್ಟೇನೆ.
ಅಷ್ಟಾದ್ರೆ ಆಯ್ತು ಸರ್.
ಇಲ್ಲ 2 acres, 8
ಅಷ್ಟಾದ್ರೆ ಆಯ್ತು.
acres ಖರಾಬ್ ಅಂತ ಎಲ್ಲೂ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಸರ್.
ಅದು
In the plaint also they have not mentioned.
ಅದೇ ಹೇಳ್ತಾ ಇರೋದು. See, when you filed a sketch.
ಇಲ್ಲ, that I am disputing that sketch. I have not signed the sketch. I have not signed the sketch. What will happen? They have obtained the signature on the compromise petition. They have shown that, telling that 2 acres, 8 guntas are allotted to us. The suit filed by them only. They have filed the suit.
Yes.
And they have filed the plaint. In the plaint also, Your Honor, they have referred that 4 acres, 20 guntas without including the Karab.
4 acres?
20 guntas. Total 4 acres, there is no.
That's a mistake, sir.
That
Total extent of land itself is 4 acres, 20 guntas.
Please, Lordship.
How can they retain 4 acres, 20 guntas and give you 2 acres,
ಅಲ್ಲಲ್ಲ, ಇದು total
8 guntas?
ಅಲ್ಲಲ್ಲ,
It is
plaint
impossible.
ಅಲ್ಲಲ್ಲ, plaint ಅಲ್ಲಿ ಅವ್ರ ಕೇಸ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಖರಾಬ್ ತೋರ್ಸೇ ಇಲ್ಲ.
We need not go into the Kharab, description mentioned in the plaint now. Admittedly, the total extent of land
On the basis
is
of,
4 acres, 20 guntas.
please, Lord.
Including Karab.
ಅಲ್ಲ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಖರಾಬ್ ಅನ್ನೋದು ಇಲ್ಲೇ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
Sir, ಇರೋದೇ ಹಂಗೆ 4 acres, 20 guntas would include Kharab. ಅದ್ ಬಿಟ್ಟು ಬೇರೆ ಇದೆಯಾ?
ಇಲ್ಲ, ಅವ್ರು ಇನ್ಕ್ಲೂಡ್ ಖರಾಬ್ ಅಂತ ತೋರ್ಸೋದೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
Sir, RTC ಅಲ್ಲಿ 4 acres, 20 guntas ಇದೆಯಾ?
ಅದೇ ಅಲ್ಲಲ್ಲ, the confusion is here. The page number
ಅದರಲ್ಲಿ
248.
Kharab 10 guntas.
Correct. Page 3 ನಲ್ಲಿ entry.
Kharab, B Kharab 1 acre, 16 guntas.
Yes.
Ainu 2 acres, 34 guntas ಅಂತಿದೆ.
Correct, please.
How you wanted to divide is not shown.
Please, Lord.
But they are saying the sketch was produced along with the compromise petition.
No, that is.
It is recorded in the compromise.
Then how did you want to divide the property?
No, they have assured me.
Please tell us, how did you want to divide the property?
2 acres, 8 guntas was
How?
given to.
In which
me.
manner?
Ain Jamin has given to.
ಎಲ್ಲಿದೆ
2 acres.
sketch?
Sketch ಕೊಟ್ಟಿಲ್ಲ.
ಮತ್ತೆ?
ಸ್ಕೆಚ್ ಕೊಟ್ಟಿಲ್ಲ, ಬಟ್ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲೂ ಅದೇ ರೀತಿ ಇದೆ. ಅವರೇ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಇದ್ ಮಾಡಿರೋದು. ದೇ ಹ್ಯಾವ್ ಅಕ್ಸೆಪ್ಟೆಡ್ ದಟ್ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್. ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಮೆನ್ಷನಿಂಗ್ ದಿ ಖರಾಬ್ ಆರ್ ಇಂಜನ್.
ಹೌದು, they have mentioned 2 acres, 8 guntas for you.
Please, Lord.
The remaining 2 acres, 12 guntas will go to them.
I have no objection. 2
Then
acres, 12 guntas.
what's the problem?
ನಂದೇನ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. ಬಟ್ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ, ಈಗ ನನಗೇನ್ ಅಲಾಟ್ ಆಗಿದೆ ಆ ಜಾಗದಲ್ಲಿ ಅವ್ರಿಗೆ ಬೇಕು ಅಂದ್ಬಿಟ್ಟು ದೇ ಹ್ಯಾವ್ ರೈಸ್ ದಿ ಅಬ್ಜೆಕ್ಷನ್ ಅಂಡ್ ಚಾಲೆಂಜ್ ದಿ ಮ್ಯುಟೇಷನ್ ಆರ್ಡರ್.
ಈ sketch ಅಲ್ಲಿ ಇವಾಗ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನಿದೆ?
ಸ್ಕೆಚ್ ಪ್ರಕಾರ ಅವ್ರು ಮಾಡಿಲ್ಲ ಸರ್.
Sketch is correct and it is recorded in the compromise petition also.
Page number 10.
2 acres, 8 guntas ತೋರಿಸಿದಾರಲ್ಲ,
Page number
ಏನ್
10
ಪ್ರಾಬ್ಲಮ್ ಇದೆ?
ಅದು ಸ್ಕೆಚ್ ಪ್ರಕಾರ ಅದೇನ್ ಮಾಡಿದ ನಾರ್ದರ್ನ್ ಅಂಡ್ ಸದರ್ನ್ ಪೋರ್ಷನ್
ಮಾಡಿದ್ದಾರೆ.
ಏನು
ತೊಂದ್ರೆ ಇಲ್ಲ ತಾನೆ?
ಅದ್ರ ಪ್ರಕಾರ ಐ ಟೇಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್. ಕೇಳ್ತೇನೆ ಸ್ವಲ್ಪ ಪಾರ್ಟಿ. ಬಟ್ ಪಾರ್ಟಿ ಗೇವ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ದಟ್
it cannot be that you will retain 2 acres, 8 guntas of fine.
ನನಗೆ ಎಕ್ಸ್ಟ್ರಾ ಬೇಡ. ಐ ಆಮ್ ನಾಟ್ ಕ್ಲೈಮಿಂಗ್. But mutation also affected with respect to 2 acres, 8
Please
guntas.
take instructions as to what is the problem if it is divided like this.
Please, Lord.
Is there any problem? ಕೇಳ್ ನೋಡಿ. ಏನಿಲ್ಲ ಅಂತಂದ್ರೆ why unnecessarily object
ಆಗ್ಬೋದು.
claim of the
Please.
Like your Lord.
anyway he is a brother or sisters only.
ಹೌದು.
ಏನ್
ಇಬ್ರು
problem?
brother.
Sister-in-law.
Sister-in-law.
She's sister-in-law is.
And entire land has been purchased by us and we have given the share to him. ಅದು amicably
ಅದಲ್ಲ ಪ್ರಶ್ನೆ. ಎಲ್ಲ ಒಪ್ಕೊಂಡು ಒಂದು
ಒಪ್ಕೊಂಡಿದೆ.
ಇತಿಹಾಸಕ್ಕೆ ಬಂದು
ಒಪ್ಕೊಂಡಿದೆ.
ಹಿಂಗ್ ಡಿವೈಡ್ ಮಾಡೋಣ ಅಂತ ಹೇಳ್ಕೊಂಡಿದ್ದೀರಾ?
ಒಪ್ಕೊಂಡಿದೆ, ಅದ್ರ ತರ ಸ್ಕೆಚ್ ಹಾಕಿ ಅದ್ರ ತರ ಆದ್ರೆ ಆಯ್ತು.
This is a case where my lord mentioned. That is why the revenue 11 is insisted.
ಅದೇ
ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಅನುಭವದ ಮೇಲೆ ಡಿವೈಡ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿ ಖರಾಬ್. ಅವ್ರಿಗೆ ಯಾವ್ದು ಐನು ಯಾವ್ದು ಖರಾಬ್ ಅಂತ ಹೇಳಿಲ್ಲ. ಯಾವ ಪೋರ್ಷನ್ ಅವ್ರಿದ್ದಾರೆ, ಈ ಪೋರ್ಷನ್ ಇಷ್ಟ ದೇ ಡಿವೈಡೆಡ್.
actually what they have done is correct only.
But the same has to be certified by a proper surveyor so that ಏನಾಗ್ತದೆ ನಮ್ಮ ರೆಕಾರ್ಡ್.
No. ಆದ್ರೆ ಇದು according to this they should have obtained a Lebanese sketch.
Yes.
ಅವಾಗ ಆ ಟೈಮಲ್ಲಿ ಇತ್ತೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ. ಯಾವಾಗ ಆಗಿರೋದು ಇದು?
Recently, 2018 last.
ಮತ್ತೆ ಮಾಡ್ಬೇಕಾಗಿತ್ತಲ್ಲ. Why did you not ask for a Lebanese sketch?
At the time of compromise.
ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ಸ್.
ಹೌದು.
ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಪ್ರಕಾರನೇ ಹಾಕೋದು ಅಂತ ಹೇಳಿ ಸ್ಕೆಚ್ ಮಾಡ್ಕೋಬೇಕು ಅನ್ನೋದನ್ನ ನಾವು ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಬರ್ಕೊಂಡಿದೀವಿ.
ಹಾ.
ಆದ್ರೆ ಅವ್ರು ಡಿಗ್ರಿ ಹೋಗಿ ಅಲ್ಲಿ ಇದು ಕೊಟ್ಟು
ಮಾಡಲ್ವಲ್ಲ ಅವರು.
ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ಮಾಡಿರೋದನ್ನೇ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು.
ಅದ್ರ ಪ್ರಕಾರ ಆದ್ರೂ ದೇರ್ ಇಸ್ ನೋ ಡಿಫಿಕಲ್ಟಿ.
ನೋ ಡಿಫಿಕಲ್ಟಿ.
ಬರ್ಕೊಳ್ಳಿ. Is coming up for the first time?
Before this honorable court is the second time not.
ಅಲ್ಲ, notice order ಆಗಿದೆ.
ಆಗಿದೆ ನೋಡಿ.
ಎಲ್ಲಾರ್ದು
They have appeared.
ಕೇವೆಟ್.
After hearing the parties, learned counsels for the contesting parties, this court finds that the dispute here in terms of the compromise petition, compromise decree drawn by the civil court is only in respect of survey number 101/3 of Devanagundi village, Anukondanahಳ್ಳಿ, Hubli, Hoskote Taluk. Full stop. The total extent of land in the survey number is 4 acres 20 guntas. Full stop. In terms of the compromise petition and decree,
Petitioner allotted 2 acres 18
the petitioner has been allotted 2 acres and 8 guntas of land.
Fifth respondent,
Full
2
stop.
acre 12 guntas.
It is therefore the contention of the contesting respondents that in terms of the compromise decree, 2 acres and 12 guntas should have been shown in favor of the contesting respondent herein.
Number 5.
However, only 26 guntas are shown in favor of the contesting respondent.
In the RTC 26 guntas are.
In the RTC. Full stop. Next para. Learned counsel for the petitioner seeks for a short accommodation, please, to secure instructions from the petitioner as to whether there is any difficulty for the petitioner to accept the sketch annexed to the compromise petition. Full stop. If there is no objection from the petitioner, appropriate directions will be issued to the revenue authorities to show an extent of 2 acres 12 guntas in favor of the contesting respondent.
Srimati Ratnam.
HP, Srimati SN Ratnam. Yes. Release this matter on 13th of March.
Publish.
Interim order may be extended.
Interim order granted earlier stands extended till next date of the.
Grateful.
Matter, my lords had heard this from RP, my lords had RP filed by BBMP, my lord. Lords had directed us to go before the competent authority court. Lord, showing that the ownership, my lord, belongs to the petitioner therein. Now, my lord, the BBMP says that they are the owners of the property. Lord, they say now they are the owners of the property and they have substantial documents to show that they were owners of the property and they were in possession of the property. Now, my lord, this before the writ petition, my lord, we had stated that they had put up a gate and we destroyed the gate and we took possession of it.
Yes.
Now, my lord, the position was with the BBMP anta avaru heltare. Paragraph 5 is what I had made assumption. My lord, now, my lord, the BBMP, my lord, on that day, my lord, I had no instructions, but now BBMP claims that the land, the gate was put up by BBMP and thereafter a compound wall was put up. Demolishing the compound wall, my lord, there's another gate which was restored. Agreed by the restoration of the gate, my lord, the petitioner was before this court, my lord. At that point of my lord, I had not got instructions, my lord, to say that the gate was put up by the BBMP or not. Now the gate which was existing before, my lord, was put up by the BBMP. My lords are directed us to go before the trial court and file a suit against the suit for declaration, declaring that, my lord, that part I'm agreed with, my lord. That's this reason, my lord, that the ownership of the property belongs to the BBMP and there are substantial documents to show that they were.
Sir, you have accepted the orders passed by this court.
Yes, the
And from the year
petition, yes.
1994,
The contempt petition, my
the
lord.
name of the petitioner's father
Yes, my lord.
was entered in the Kata register of your own
Yes.
department.
Yes,
Then-
that is also being challenged, my lord.
Huh?
That is also being challenged.
Challenge it. So what?
Yes, my lord.
No grounds. Just because you claim that is your property, it doesn't mean that you should not go to the civil court at all.
Yes, my lord.
Everything will be decided by you and your own authorities. Angala agadilla. If there is a dispute regarding the title of the property, like any other ordinary citizen, you also have to go to the civil court only. You cannot take law into your own hands and say, I'm going to decide who, whether I'm the owner or the other person is owner. Madak baradilla. Barkal. This review petition has been filed at the hands of the Commissioner, Brihat Bengaluru Mahanagara Palike, and the other officers of the BBMP who were respondents in the writ petition. Full stop. Next para. Learned counsel for the review petitioner seeks to contend that certain factual observations made by this court that it was contended on behalf of the BBMP that the petitioner removed the gate that was put up by the BBMP, and the petitioner thereafter raised a compound wall in the place of the gate. Was not a submission made after seeking necessary instructions. Full stop. Further, it is pointed out that in paragraph number 7, this court has held that if the BBMP claims title and ownership over the land in question, the BBMP has to approach a competent authority bar court seeking a declaration of title in favor of the BBMP. Full stop. Next para. Having regard to the grounds raised by the BBMP in the review petition, this court does not find any reason to accept the contention of the review petitioner that there is any error apparent on the face of the record. Full stop. Since the BBMP is seeking to contend that it is the owner of the property, comma, it would be incumbent on the part of the BBMP to seek such a declaration. Full stop. Next para. No grounds made out for interference. Full stop. Accordingly, the review petition stands dismissed. Obliged. This is the third time that the matter is coming up for non-compliance of office objections. Full stop. Earlier, 2 weeks time was granted by order dated 5/1/2024, and one more week was granted by order dated 14/2/2024. Full stop. Next para. Nevertheless, release this matter on 13th of March 2024. Full stop. If office objections are not complied by the next date of hearings, the review petition will be dismissed. Yes. 17 same, huh? Same.
I'm putting for respond to. It was disposed of.
Huh?
It was disposed of,
Hmm.
and the memo filed by us, only to consider in the representation filed by the petition in that case. Taking memo, this was dissolved, could dispose of the writ petition. Now, the third party has come filed writ petition stating that it required for some other purpose. Identical, my lord, the very order was challenged by the another person before division bench dismissed.
So this review petitioner was not a party to that proceedings.
No.
Ah.
The list is between the fourth respondent and the KADB. That they allotted a flat and sought for direction to give proposition certificate. We filed a memo, it will consider issue the certificate. At that, another person also prepared a writ appeal. Question in the very same order. This all called the division bench dismissed. That is that we go approach authorities.
So ಅವ್ರುನು ಇದೇ ತರ seeking to raise
same,
another
another person.
it was marked for
ಅವ್ರು ಹೇಳೋದು it is for some other civic community
ಅದೇ,
side,
ಅದೇ.
ಅದೇ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು public purpose.
ಅಂತ ಹೇಳ್ತಾರೆ. So if that is the case, that's what divisional bench observes that. ಅದು it's independent ಕಾದಪ್ಪ.
ಆಯ್ತು, ಇನ್ನು ಇದುವರೆಗೂ ಏನು ಡಿಸಿಷನ್ ತಗೊಂಡಿಲ್ವಾ?
ಇಲ್ಲ ಅದೇನಾಯ್ತು ಫರ್ದರ್ ಇದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಬಂತು ಅಂತ ಪೆಂಡಿಂಗ್ ಇಟ್ಬಿಟ್ರು.
ಬರ್ಕೊಳ್ಳಿ. Matter is called out. There is no representation for the petitioner. So, however, learned counsel Shri P.V. Chandrasekhar appearing on behalf of the respondent KDB.
1 to 3.
KDB ತಾನೆ?
1 to 3. Fourth respondent ಬೇರೆಯವರು ಇದ್ದಾರೆ.
I said for KDB. Has furnished a copy of order dated 9th of October 2023 passed by the Honorable Division Bench in a writ appeal number 1224 of 2023. Full stop. Learned counsel submits that similar to the grievance of the review petitioner herein, the said appellant also sought to raise an objection regarding allotment of plot number 5A.
Question the order passed by your lordship before the division bench.
ಅದೇ plot number 5A ತಾನೆ ಸೇಮ್.
ಅದ್ರದ್ದು ಆಕ್ಚುಲಿ ನಮ್ಗೆ ನೋಟಿಸ್ ಆಗಿಲ್ಲ, ದಟ್ಸ್ ವಾಟ್ ಎ ಕ್ವಶನ್.
Must be that was there was only one order ಅಲ್ವಾ?
ಹೌದು, ಒಂದೇ ಆರ್ಡರ್.
ಅದೇ
this order under review has been questioned by the
ಏನ್ ಹೇಳಿದೆ? Allotment of plot number 5A
My submission is
of Paikampadi Industrial Area, Mangaluru.
the very order under review has been questioned by some other person. This is observation.
In favor of
The fourth respondent.
respond number 4 here.
Four.
Full stop. The division bench did not accept such a contention and dismissed the appeal
This certain observation.
with the observation that all contentions are left open to the authorities at whose hands such consideration should take place. Full stop. It was also directed that it is open to the appellant to put forth his version between this before the said authorities by making an appropriate representation accompanied by supportive material. Full stop. Next para. However, since there is no representation for the review petitioner, release this matter on 13th of March.
Appealing for, in this case, my lord, petitioner challenged the order of the deputy commissioner before the Sam Court, my lord. Since, my lord, my land friend is
Steps to
appealing
be
for the
taken
petitioner,
in
has
respect
filed
of-
memo stating that there is a proceedings before the Tahsildar, Bangalore North Taluk, and proceedings have been closed. In fact, my lord, there was no
The-
proceedings.
What you matters come up for orders
Orders, my lord.
regarding steps to be taken. You have filed an IA recalling the order dated 6/2/2021.
Respond number 6, my lord, who is none other than the father of the respond number 5, my lord. He is the legal error and record. I may be treated as legal error as,
You have to file a memo,
I will
sir.
file memo to that.
What is this IA one for recalling order dated
My lord,
6/2/2021?
Some court, my lord, disposed of the writ petition on the basis of the memo submitted by the petitioner council stating that the matter before the Tahsildar has been closed. Therefore, my lord, writ petition will become infructuous, my lord. In fact, my lord, on that time, my lord, there were no proceedings pending before the Tahsildar. In fact, the order of the deputy commissioner which was challenged and it is pending before the Sam Court.
That the petition may, learned counsel for petitioners filed a memo
That's right.
stating that petition may be dismissed as having become infectious. Memo is placed on record. Petition is dismissed as having become infectious. ನೀವೇ ಫೈಲ್ ಮಾಡಿರೋದು
ಅದು my lord, it is wrongly filed, my lord, by my land friend, my lord.
ಅದಕ್ಕೇನ್ ಮಾಡಿ
Petitioners were in abroad, my lord. When they came back to Bangalore, my lord, on verification, my lord, the petitioner council has filed memo stating that the matter before the Tahsildar has been, in fact, there was no proceedings before the Tahsildar pending as on that date, my lord. In fact, the matter was challenged. Deputy commissioner order itself was challenged. Matter itself was not remanded to any person. By an inquiry, my lord, I don't want to make any submission. my lord. Sometimes, my lord, wrong memos on.
Oh, you were not the learned counsel appearing for the petitioner.
Papi Reddy was appearing, my lord.
He will not be permitted.
Right.
There is a judgment of the Supreme Court which says it should not be permitted.
ಅಲ್ಲ ಅವ್ರು ಕೇಳೋರು ಅವ್ರೇನು
No, no, no.
explanation to
No,
file.
no.
I will ask him to
Only
file.
that counsel has to file an application
I will-
because he will have to answer.
Yes, my lord. That I know.
Ah,
ಅಲ್ಲ
that is
ಅಲ್ಲಿಗೆ
why the Supreme
therefore, my
Court
lord,
has
I
said, don't
submitted.
entertain a review petition or such application at the hands of another counsel who was not the person who made that submission.
Therefore, my lord, I submitted. I don't want to make any allegation.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ನಾವು. Only that advocate has to come before the court.
I will request him to, you will also kindly out next week, my lord. I will request him to make necessary affidavit or. In fact, my lord, ಕೇಳಿದಾಗ ನಾನು ಹಾಕಿಲ್ಲ ಅಂತ ಸಿಗ್ನೇಚರ್.
ಯಾವ್ದೋ ಮೊನ್ನೆ ಒಂದು ಯಾವ್ದೋ ಒಂದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ that Supreme Court judgment was noticed that such a review petition should not be permitted at the hands of the learned counsel who was not the person who argued the matter.
ಹೌದು recent judgment.
ಅದನ್ನ
Earlier also it was there, my lord. Supreme Court judgment, the same advocate has to be filed the review
ಹೌದು.
petition. That I am aware, my lord. It is for recalling, my lord, therefore.
ಅದೇ why should we recall at your instance, sir?
Please, my lord, please.
Let that learned counsel come and
Please,
say,
please.
yes, ನಾನ್ ತಪ್ಪು ಮಾಡಿದ್ದೀನಿ ಅನ್ಬಿಟ್ಟು.
ಹೌದು.
ಇಲ್ಲಾಂದ್ರೆ ಆಗೋದಿಲ್ಲ.
Please, my lord. You will also kindly out next week, my lord, I will request my land. friend.
Having regard to the judgment of the Honorable Supreme Court in the case of so and so, the application filed in IA number 1 of 2023 to recall order dated 6/2/2021 at the hands of learned counsel Sri R.P. Somshekaraya is not maintainable. Full stop. Learned counsel seeks for a short accommodation to secure instructions from the petitioner. Release this matter on 13th of March.
13th, my lord. I will also kindly until 15th, my lord.
15th of March. Right.
For the petitioner, Your Lordship. Your Lordship, in this case, the petitioner is expired.
Furnishing of process fee for service of notice on respondent number 7.
We'll file dispensation memo for respondent 7. Your Lordship.
Huh?
I'll file dispensation memo for respondent 7. In this case, petitioner is expired, Your Lordship. He was murdered by the contesting respondent.
Which petitioner?
Petitioner
There are
one.
two.
Petitioner 1, Your Lordship.
Hmm.
He was being murdered by contesting respondent number 5.
Huh?
Respondent 5 had murdered this petitioner number 1, Your Lordship. There's a criminal case against him. We'll produce with the death certificate.
Srimati Anuleka Avinash. Why are you seeking a dispensation of notice?
Because she's saying she's not willing to contest the matter, Your Lordship. That was the instruction given from CJI.
How can you take that risk unless someone else comes and says? Anyway, it is up to you. File a memo
Please, please.
My lords.
and you will have to take steps.
Your Lordship, insofar as petitioner number 1, there is no LRs, Your Lordship.
ಅದಕ್ಕೊಂದು ಮೆಮೊ ಹಾಕ್ಬೇಕಾವಾಗ.
ಹಾಕ್ತೀನಿ, Your Lordship.
Please file.
Along with death certificate and FIR copy, I will submit it.
ಅಲ್ಲಲ್ಲ, you will have to file an affidavit on behalf of petitioner number 2
Please.
stating all these facts.
Please, Your Lordship.
Yes.
My lords, regarding vacating of stay, my lords, we have served the copy to AG. The needful is done, my lord.
Learned counsel for petitioners submits that petitioner number 1
Please,
is no more.
please, Your Lordship.
Full stop. The learned counsel further submits that the petitioners will seek dispensation of notice in respect of respondent number 7. Full stop. In regard to both the aspects, the learned counsel seeks for a short accommodation to file necessary memo. Full stop. Next para. Learned counsel for respondent number 5, who has filed IA number 1 of 2022 for vacating the interim order, submits that a copy of the IA has been served on the learned HCDP. Full stop. Next para. Release this matter on 13th of March.
Please, pleasure.
A week's time is granted to the petitioner for payment of court fee. On 21/2/2024, the following order was passed. Extract ಮಾಡ್ಕೊಳ್ಳಿ. Next para. Matter is called out. There is no representation for the petitioner. Full stop. Office objections have not been complied. Full stop. Accordingly, the writ petition stands dismissed for non-compliance of office objections. The same order. Order dated 21/2/2024. ಬಂದಿದ್ದೇನ್ರಿ ಕಾಪಿ? ಕಾಪಿ ಬಂದು. ಬಂದಿದೆ. Learned HCDP submits that he has received copy of the writ petition. Yes.
Last time, the said matter, there was a direction to verify because the same land was granted to some other people in the same survey number. ಇದು ಭದ್ರಾ
Two other persons, it has been granted.
My instructions will not, now they are in the process of cancelling the grant what is made to those two people. ಅವ್ರ ಗಮನಕ್ಕೆ ಬಂದಿಲ್ದಿರ ಮಾಡಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. But no action has still been initiated.
ಆಯ್ತು, ಬರ್ಲಿ ನೋಡೋಣ.
The petition is served on the copy has been served, my lord. I will file the.
You received copies?
I have not received it. They must have filed before them.
I filed it in the counter, my lord. I will serve it again today.
Please serve. List this matter of the service of notice on respond number 4. Full stop. In the meanwhile, a copy of the writ petition shall be served on the learned HCDP.
Don't want any hand summons, my lord.
Huh?
Hand summons better, somebody, through court house.
ಹೋಗಿದೆಯಲ್ಲ ಆಗ್ಲೇ
ಅದು ಹೋಗಿದೆ.
ನೋಟಿಸ್ ಹೋಗಿದೆ, so therefore we are awaiting service of notice. Yes.
I filed the amended cost statement in my note.
Please carry out the amendment. Learned counsel for the petitioner submit that the amendment in the cost title shall be carried out during the course of the day.
That's
The matter, my lord, with respect to the impugned order, my lord.
Lord, I am for the contesting respondent in this. Lord.
You have
Lord,
received
made
a copy of the
submission.
writ petition, Mr. AGA?
Yes, my lord, I have received one.
Learned AGA submits that he has received copy of the writ petition.
Lord, I am seeking for some time in this matter.
Lord, already 3 times they have taken time, my lord.
Lord,
But 3 times they have taken time, my lord. In view of the impugned order, my lord, they have changed the mutation. And now they're trying to create third party right, my
My
lord.
Lord, there is an interim order in there
In spite of
protecting
the
their
impugned order
interest.
by this honorable court, my lord, they're trying to alienate the property by creating a third party right in this. my
ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗತ್ತಮ್ಮ? How will they do it?
lord.
When there is an interim order, how will they do it?
That is what my instruction, my lord.
They will be hauled up for contempt. Yes.
one submission, my lords.
Here,
That's one submission,
my
my lords.
lord.
26.1, my lords. In that, my lords, I have been amended the cost rate, my lords. I am also filing the amended cost rate.
ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಮಾಡಿದೀರಾ ಇವರು
ಅದ್ರಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ, ಇದ್ರಲ್ಲಿ amended document.
in the connected in the connected writ petition, learned counsel has carried out the amendment in the cost title and
And
is
amended
furnishing the amended cost title.
Only a date may be fixed.
Full stop. The same is accepted.
The interim order may kindly be extended in the item
Interim
number.
orders granted earlier stand extended till the next date appear.
And
Right.
a date may be fixed, my lord.
2024 matter, ma. How can there are old matters? We'll see. Yes.
The impugned is order, my lord, is of the year 72 mutation, my lord, has been after 46 years has been.
You have
changed
stayed it.
At the.
You have
instance
stayed
of
it.
the-
We'll see. Yes.
Because, my lord, they filed an injunction suit before the trial court. They are making all effort to create a third party right. That's all my only submission.
It's only
Kindly,
a suit for bare injunction.
please, my lord, kindly a date may be given, my lord.
ಆಗಲ್ಲಮ್ಮ, ಇನ್ನು ಹಳೆ ಮ್ಯಾಟ್ರುಗಳು ಬಹಳಷ್ಟು ಇದೆ ತಗೊಳ್ಳುವಂಥದ್ದು. Let us see. Yes. Yes. Non-filing of acknowledgement. The copy has been given. Learned AGA submits that he has received copy of the writ petition. List this matter after service of notice on respond number 5. Interim order idea. Huh? Interim order granted earlier stands extended till the next date appearing.
Regarding service of notice, but I served copy today. Today I served the copy. Government.
Only state is the respondent, is it?
No, respondents, other respondents are there, but the day before yesterday's matter, my lord, Lordship suggested for, as the revenue entries made in the name of the petitioner based on the sale deed.
Please. Other.
Now, one submission, my lord, my vendor, one of the vendor, my lord, filed a writ petition before this honorable High Court. But wherein the order of the deputy commissioner has been stayed, my lord, in WP number 2514/22. And this may be post along with that, my lord, has to be corrected. Very same order has been challenged by one of the vendor, respondent number 28 herein, by filing the writ petition. This honorable High Court also granted on 15/12/2020 interim order of stay.
List this matter along with WP number
25140/22.
2022. Please. Yes.
In respect of other respondents, notice is not at all. Private.
ಅವರು ಇದ್ರಲ್ಲಿ. We'll ask the learned counsel to take notice.
Please.
Okay, for the petitioner.
Yes. Review petition.
Review petition, delay there. Delay of 237.
Our objections file ಮಾಡಿದ್ದಾರೆ.
Madilla, Madilla.
Huh?
Madilla, they have not filed.
Last time he was saying he wants to file
Wants to
objection.
put up the record. Now record is put up.
Petition papers.
First may take this matter next week. No, that's
Matter is called out. There is no representation for the contesting respondents. Full stop. Release this matter on 13th of March.
This matter, petitioner's father and brother have filed an application for the land tribunal, wherein during the pendency of the land tribunal proceedings, the father has died, the brother has taken the GPA from the sisters to represent all these.
Permission to prosecute.
Yes, one matter, she was not the party before this honorable court in the writ proceedings, For that, I have filed the application for seeking the permission to prosecute the matter.
Which is the order?
Order in annexure, annexure G, ink page number 44, The impugned order to the writ petition is ink page number 35, next in that writ petition, your lordship may impugned order.
To register the name of all the legal heirs of Sri B.R. Chengappa.
Yes, B.R. Chengappa. But the B.R. Ramappa is the original applicant, my father, The B.R. Ramappa is the father of petitioner and B.R. Chengappa before the land tribunal. But the B.R. Chengappa has taken the GPA for representing all the persons. Your lordship may, for a moment, take the page number 36,
Deceased B. Ramappa had filed the
application before the land
application.
tribunal. Please, the petitioner is the daughter and the
daughter of Ramappa.
Ramappa. Chengappa is the brother who taken the GPA representing all the, including the petitioners and others before the land tribunal. However, he has challenged before the Honorable Court the impugned order in ink page number 35. In that order also, ink page number 36 ಅಲ್ಲಿ last para may I read ಭೂ ನ್ಯಾಯಮಂಡಳಿಯು ವಿಚಾರಣೆ ನಡೆಸಿ ಕಡತದ ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಅರ್ಜಿದಾರ ಬಿ.ಆರ್. ಚಂಗಪ್ಪನವರು ದಿನಾಂಕ 5/9/1981 ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಮುಂದೆ ಹಾಜರಾಗಿ ತನ್ನ ತಂದೆಯವರು ದಿನಾಂಕ 14/3/81 ಪೌತರಾಗಿರುತ್ತಾರೆ ಎಂದು ಹೇಳಿಕೆ ನೀಡುತ್ತಾರೆ. ಮೃತರ ವಾರಸುದಾರರಾಗಿ ತನ್ನ ತಾಯಿ ಮತ್ತು 3 ಜನ ಸಹೋದರಿಯರು ವಾರಸುದಾರರಾಗಿದ್ದು ವರ್ಷಗಳಿಂದ 3 ವರ್ಷಗಳಿಂದ ಹಿಂದೆ ಅರೇಬಿಕ್ ಕಾಫಿ ಸಾಗುವಳಿ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. The petition, including petitioners, they have cultivated the land
admittedly. However, he has not made them as a party to the proceedings before the Honorable Court and obtained the order only in his favor, my lord.
Learned AGA takes notice for respond number 1.
Respond number 1 is the,
Issue notice to response number 2 to 7.
yes, please, my lord.
The petitioner is also permitted to serve a copy of the review petition
Prakash L. Shetty, my lord.
on learned counsel Shri Prabhakar L. Shetty
Shetty. And also Priya K. who represented.
and learned counsel Srimati Priya K.
K.
Yes.
Matter, I am appearing for the petitioner matters. Petition number 4 have died, my lords, and I filed a LR application, my lords.
IA 3 of 2024.
Yes, my lords.
This is petitioner number 4.
Yes, my lords. Only legal air, my lords. My Mr. Manish. He has died on 4/10/2023, my lords.
Where is your application to bring the LRs on record?
It's filed, my lords.
IA
Filed
1
on
of
16th
2024 for condonation of delay.
Delay is not present, my lord. There is no delay, my lords.
Ah.
It is filed on 16th February 2000.
But where is your application? See, there are only two applications here.
Yes, my lord. Delay application is not there, my lords.
Huh?
Bringing LRs, my lords, and abatement. Both the applications are there. I have filed a separate application.
ತೋರಿಸ್ರಿ ಅವ್ರು. ಯಾವ್ದ್ರಲ್ಲೂ ಇಲ್ಲ. ಹ? There is only one person.
Yes, my lords.
Huh?
Mahesh, yes, my lord. Only legal air, my lords.
Orders on IA number? Huh?
3 of 2020.
2 and 3
Yes, my lords.
of 2024. These applications are filed by the
Petitioner, my lord.
ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Petitioner, my lords.
ಯಾವ petitioners? Huh?
My lords, legal.
Surviving petitioners ಹಾಕಿದಾರಾ ಅಥವಾ this proposed applicant ಹಾಕಿದಾರಾ?
Proposed applicant, my lords.
ಯಾರ್ದು affidavit? ಮಹೇಶ್.
Mahesh, my lords. He is the legal heir of the petition number 4, my lords.
By the legal heir of
Petition number 4.
petitioner number 4, Shri Siddegowda,
Yes, my lords.
seeking to come on record on the demise of the fourth respondent,
Fourth petitioner.
fourth petitioner, full stop. There is no delay.
No, my lords.
Full stop. However, there is an application filed seeking to set aside abatement. Full stop. Next para. Having regard to the nature of the dispute brought before this court and the fact that there are other petitioners contesting the matter, comma, the applications are allowed while setting aside abatement. Full stop. The proposed petitioner is permitted to be brought on record as the legal representative of deceased petitioner number 4.
Yes.
Full stop. Learned counsel for the petitioner shall carry out the amendment in the cause title and furnish amended cause title within a period of 1 week from today.
Okay.
Petition 1 and 3, your lordship.
Yes.
Recently, just now I received a message.
2014.
Petition number 1 expired.
ಅದು application we have paid. Respond number 7. Petition number 7.
Also respond number 3.
Respond.
You have already filed application.
Respondent number 1 died.
Gotaito. You have already filed applications.
We have filed it.
Huh?
Petition number 7 filed this application. Petition number 7 filed this application.
ಎಷ್ಟು ಜನ ಕೌನ್ಸಿಲ್ಸ್ ಇದ್ದಾರೆ? ಎಷ್ಟು ಜನ ಕೌನ್ಸಿಲ್ಸ್ ಇದ್ದಾರೆ?
ಇದರಲ್ಲಿ ಇಬ್ರು
1 and 3 ನಾನು.
1 and 3 ಗೆ ಇವರು. ರೆಸ್ಟಿಗೆ ನಾನು.
ಮಿಕ್ಕಿದವ್ರು ನೀವು?
ಹೌದು.
ಇದ್ರ ಮೇಲೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆಯಾ? ನೀವು ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿ
ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಯಾರು? CN ಕೇಶವಮೂರ್ತಿ. R3 A and B.
R3 A and B. ಎರಡೇ ಜನ ಮಕ್ಕಳು, ಒಂದು ಹೆಂಡತಿ ಮತ್ತು ಒಂದು ಮಗ.
Orders on IA number 1 to 3 of 2023. These applications are filed by the petitioners to bring on record the legal representatives of deceased respond number 3. Shri CV Ramakrishna. Full stop. Comma, while seeking condonation of delay of 511 days in filing the application and to seek and to set aside abatement. Full stop. Learned counsel. Shri CN Keshavamurthy has entered appearance for the proposed respondents. Full stop. In that view of the matter, the applications are allowed while condoning the delay and setting aside abatement. Full stop. Learned counsel for petitioners are directed to carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. Full stop. Next para. Learned counsel Shri Kishan Dutt Kalaskar.
Nagaraju. Petition number 1 died recently.
You are Mr. Kishan Dutt.
Nagaraju. He has given to me now. I'm handling. I filed my wakalat.
ಯಾವಾಗ್ರಿ?
ನಾಗರಾಜು ಅಂತ ಇದೆ.
ಎಲ್ಲಿ ಬಂದಿದೆ? ನಿಮ್ಮ ಹೆಸರು ಬಂದಿಲ್ವಲ್ಲ?
ಬಂದಿದೆ, ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಬಂದಿದೆ, ಬಟ್ ಅದ್ರ ಬಂದಿದೆ. ಅಪಿಯರ್ಡ್ 3-4 times. ಹಿಂದೆ ಬಂದಿದೆ. ಸ್ಟೇಟಸ್ ಅಲ್ಲಿ ಬಂದಿದೆ. ವಕಾಲತ್ತು ಆಲ್ಸೋ ಫೈಲ್ಡ್.
ನೋಡಿ ಚೆಕ್ ಮಾಡ್ರಿ. ವಕಾಲತ್ತುಗಳು ಎಲ್ಲಿದ್ದಾರೆ?
ನಾಗರಾಜು ಅಂತಿದೆ. I don't have it. Right from the- If I ನೋಡಿ ಅದರಲ್ಲೇ ಇದೇನು ಸಿಗ್ನೇಚರ್ ಮಾಡಿರ್ಬೇಕು ನಾನು.
ಅವ್ರ ಜೊತೆಗೆ ಮಾಡಿದೀರಾ?
ಹಾ ಮಾಡಿದ್ದೀನಿ
ಅದೇ ವಕಾಲತ್ತು.
ಮೋಸ್ಟ್ಲಿ. ಇಲ್ಲ ಅವ್ರದ್ದು ಇನ್ನೊಬ್ರು ಇಷ್ಟಂದ.
You are appearing along with him.
Yes, yes, your lordship.
Learned Counsel Sri Kishan Dutt Kalaskar submits that petitioner number one
died.
Shri
Muniyappa
Muniyappa is no more.
is there. ನಮಸ್ತೆ ಬರ್ತಾ ಇತ್ತು.
This has not been accepted because there is no NOC.
You know, jointly we are working. We are working together.
ಇಲ್ಲ ಹಾಕಿಲ್ವಲ್ಲ ಹಂಗಂತ.
ಇಲ್ಲ, we are in one office.
Kishan Dutt Kalaskar. Anyway, petitioner number one, Sri Muniyappa is no more. What do you want to do?
No, I will file a lot of application together with
Necessary
member.
applications are required to be
That's a-
filed to bring the legal representatives on record.
Yes.
Stop. A week's time is granted to do the needful.
Petitioner in the first matter have filed LR applications in respect of 6 and 7. Notice has to go.
Lordship, appearing for respondent number 12, your lordship. Humble submission expire, respondent number 12 ಕೂಡ recently ತೀರೋಗಿದ್ದಾರೆ ಅಂತ ಮಾಹಿತಿ ಬಂದಿದೆ ನಮಗೆ.
12.
Issue notice
All the
first matter.
on IS number 123 of 2024 and 426 of 2024. To the proposed respondents. Full stop. Next para, Learned Counsel. Shri
Adish Kulkarni.
Huh?
Adish Kulkarni.
Harish Kulkarni.
Adish.
Adish Kulkarni. Appearing on behalf of
Respondent number 12, Swami.
respondent number 12 submits that respondent number 12 is also no more. Full stop. Learned counsels for the petitioners are required to take note of the same and file necessary application to bring the LRs on record.
As per office note in WP 53, 52 of 20, steps to be taken in respect of deceased 5A. I will take steps.
5A.
ಹೌದು 5A.
In the next para, in the connected matter, a week's time is granted to the petitioners to take out,
Steps
to take steps for service of notice
in respect of deceased or 5A. I have to bring the legal aids of respondent number 5A.
5A now.
ಹೌದು 5A.
Huh?
53, 52 of 20 ನಲ್ಲಿ ಅಲ್ಲಿ
In respect of the deceased respondent number 5A.
5A.
Yes. How about 33.1? ಅದು ನಿಮ್ದೇನೆ?
ಅದು ನಮ್ದು ಅದರಲ್ಲೂ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡು
ಹಾ?
ಅದರಲ್ಲೂ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡು ಎಲ್ಲ
He has filed one common application for both the respondents, this is respondent, ಅದು office objection.
I will look into the office of
The learned counsel for the petitioner in WP number 54373 of 2016 is also required to comply with the office objections raised on IA number 1 of 2022. Yes. Where is Mr. Ravindranath A? Yes.
I filed wakalat today, my lords, on behalf of respondent number 3.
Matter is called out. There is no representation for the petitioner. This matter on 13th of March.
Taken upon Tuesday, my lord,
Appear for the
36 and 37. 35, they have filed application for vacating interim order. Matter has to be heard.
Or matter.
34 entries regarding entries, my lord.
Make your submissions, we'll dispose of the matter. What is there?
Senior
No question of vacating interim order.
senior engage ಮಾಡಿ is held up in Tuesday.
At the request of learned counsel for petitioner, release this matter on 12th of March. All right.
I appear for the counsel for the petitioner, my lord. My petition number 2 died on 21/10/23, my lord. Application is in time, my lord.
IA 1 of 2023.
Yes, my lord.
Copy is not being served, my lords.
Not served. Then matter
The
will
appeal
allow
of
the application. Order on IA number 1 of 2023. This application is filed to bring the legal representative of deceased petitioner number 2 on record. Full stop. There is no delay. Full stop. Consequently, the application is allowed while permitting the legal representatives of deceased petitioner number 2, Shri Gopal Gowda K, to come on record, to be brought on record. Full stop. Learned counsel for the petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today.
May I make one more submission, my lord?
Huh?
One more submission.
Huh?
Lord, impugned order is section 25 of the Karnataka Land Revenue Act. Lord, the main order is passed allowing the Lord appeal. Assistant Commissioner passed an order for exercising power under section 25 of the Land Revenue Act, reversing the main order. That's all the question.
The appeal itself is not maintainable, my lords. The petition itself is not maintainable on 2 grounds, my lords. See, whatever the order has been passed by the ST Commissioner, it has to be challenged before the, my lords, Deputy Commissioner by way of review petition number 1, my lord. Second aspect, my lords, without there being any documents, my lords, without the.
They are challenging the order of the Assistant Commissioner.
Grateful, yes,
for this court.
Yes, my lord.
For section 25 of the order passed under section 25 of the Lord Land Revenue Act, I will not file a review appeal at all. This court has held. No review is maintainable under section 25 of the Land Revenue Act. Kindly see the order also.
They have challenged that, madam. 132 challenge, an order was passed, madam. Then
There
the
are-
application was filed under section 25, seeking review of the order passed by the Assistant Commissioner. That has been challenged now.
No, they challenge the order of the Assistant Commissioner.
Still their order was challenged. 136(2) was challenged, and the order was passed by the Assistant Commissioner. After that, an application was filed under section 25, seeking the
Rectification of the order.
Of the AC. On that application, he has reversed his own order.
But this court has held, my lord. Review is not maintainable.
You filed the application.
No, my lords. In fact, my lords, the rectification order is only on ground that, my lords, the earlier, the annexure, see, as on the date of filing of the annexure, see, my lords.
Kindly take what?
Yes, not-
Annexure C order, my lord.
Yes, come to
Annexure
conclusion
C,
that, my
page
lords,
24. The main order. Petitioners have filed
The first order is at Annexure A.
Annexure C, my lord. Annexure C, first order.
Annexure C now, first.
See, my lords.
Yes, Lord, first order. RA number, my lord, 8 of 2020. we have, petitioners have filed that, my lord, appeal. That order is, my lord, appeal is allowed. Then, my lord, I filed an application, petitioner filed an application to rectify survey number. Annexure D order is passed rectifying survey number, my lord. Annexure D order. Page 29.
Who filed the application?
But I filed the application for correction of survey number in the main order.
No, my lord.
That has been corrected, annexure D, page 29. Thereafter, my lord, petition number 2 to 4 filed application for review the order under section 25 of the Act, Land Revenue Act. The Assistant Commissioner reverses the said order.
One nimsha.
Yes.
Annexure D.
Yes. Annexure D.
One nimsha. Authority has
Yes.
passed an order dated 8/12/2022 by allowing the appeal filed by the appellant. Subject matter
Yes,
of the
sir.
appeal. After passing of the order, survey number so and so has been renumbered as survey number
Yes, sir.
129. Hence, it is
Yes.
necessary to read survey number 108/7 as survey number 129 of Avalalli
Yes,
village.
sir.
Accordingly,
Yes, Lord.
modified.
Yes.
Amele?
Thereafter, petition number, respondent 2 to 4 filed, not IA for reviewing the order. Kindly take page 18, page 18.
Annexure A is the application.
No, application,
Order.
order,
Order on
18.
application under
Yes,
section
Lord.
25.
Yes, that is the power of Assistant Commission reversing all order.
Review the
in the
order
appeal.
dated 8/12/2022.
Yes.
And rectification order dated so and so passed in the captioned appeal.
Yes. No, my lord, he reverses all orders. This court, my lord,
Yes.
on and often, my lord, held section 25, the power of review cannot be, there is no power of review at all. Kindly take section 25. my lord.
Saving of inherent powers of a revenue code.
Yes, Lord.
Nothing in this act shall be deemed to limit or otherwise affect the inherent power of the revenue code to make such orders as may be necessary for the ends of justice or to prevent the abuse of the process of the revenue code.
Yes, my lord. There's only inherent power to correct it. Any my lord, mistake is there.
That was rightly invoked
Yes,
for
my lord.
correcting the survey number.
Survey number.
D was correct.
That was invoked rightly for correcting the survey number.
Survey number, my lords.
How could you file an application for review of the order?
That's one submission. my lords. As per the annexure, my lords. Kindly turn to the page number, my lords.
No. Technically, please tell us, how could you file this application
So
under
during the
section
pending of the
25
annexure C, my
for
lords,
review?
my lords, during the pending of the review petition, my lords,
Yes.
the respondent number 5 to 7 has not been placed for certain matters which has been pending before this honorable court.
Provision illa alli.
One submission.
Under section 25, there is no such provision.
That's earlier.
Therefore, they are rightly challenging that order.
That's one submission.
You have to go before the deputy commissioner. On the other hand, you are now saying, no, they should have gone before the deputy commissioner.
So why
Challenge this order. Baradilla.
one submission, my lords. See, earlier, my lords, during the pending of the petition, the petition which is before the second respondent, my lords, the petition, respondent number 5 to 7 has been challenged before the honorable court in order to conduct the podium duress, my lords. Accordingly, the writ petition has been disposed, my lords. Based on that, my lords, the survey number, resurvey number has been conducted. Based on that, during the interim, my lords, they are not fulfilling the conditions as per terms of the writ petition, my lords. We have prepared a contempt petition. During the pendings of the, my lords, contempt petition, my lords, the podium has been conducted and duress has been recently, my lords, on 1st December 2022, the contempt petition is being dropped, my lords. One aspect. Second aspect is
2022.
23 minutes.
23.
23 minutes. Correct, sir.
Order though.
Sir. This is the order.
December, 1st of December 2023.
23 minutes. And these documents has not been placed before the second respondent, minutes. And even after minutes, he was a member to the reconstruction minutes, the page number 18 minutes for a kind moment. Actually, Shall I read first pair? Respondent number 2 to 4 have filed application under section 25 of the Kerala review of the order 8/12/2020 and rectification order dated 4/1/2023 passed in the application captioned appeal. The respondent number 2 to 4 have filed a copy of the order sheet on 25/11/2020 in writ petition number 1345 so and so passed by the Honorable High Court of Karnataka and B minutes. The copy of the contempt petition number 251/2020 civil appeal number so and so. C minutes. The copy of the Assistant Commissioner Bangalore North Subdivision so and so 23/9/22. The order of minutes and dated 3/9/22 to passed by the Committee of the Reconstruction of the Records and E minutes. The copy of the port in Durast order has been parted on 18/10/2022 in respect of the land bearing survey number 108 but assigned as the new survey number so and so. But these documents has not been placed at the time of considering the annexure C minutes. He has not considered. Now minutes, I would like to go to page number 20 minutes, the order, impugned order minutes. Page number 24. As therefore said, the documents we are not produced before this authority as of the date of the passing of the order dated on 8/12/2022, the rectification date order dated on 4/1/2022. Hence, this authority has passed the above orders only on the available documents in orders. Hence, in the interest of the justice and equity, and on the basis of the Air Force documents, order dated 8/12/2022, rectification order dated so and so, are hereby recalled and consequently the appeal filed by the appellant is dismissed. And the respondent number 1 is directed to continue the names of the respondent number 2 to 4 in the revenue records as land bearing survey number 108/7, new survey number 129, measuring 3 acres 10 guntas, situated Avlalli so and so, as per the MR number 31/11 and 12 minutes. Minutes without any there being any documents of this minutes, the MR number has been created by the appellant's minutes. The findings has been given by the Assistant Commissioner minutes.
Therefore is whether this kind of an order could be passed by the Assistant Commissioner under section 25.
Only findings minutes, page number 27 for a kind moment.
It may be correct, sir, but he has no such powers. Unlike the High Court or the Supreme Court, where it has got the powers to recall its own orders. Our powers so avrigilla alli. That is the submission being made by the learned senior counsel.
Reported ILR 2015-3275. There are 2 decisions of this court on that point.
This is an order of by this honorable court also. Even Deputy Commissioner under section 25 cannot exercise body judicial authority and daily.
So you can obtain the same order at the hands of the Deputy Commissioner, but not by filing it.
Meanwhile, the respondent number 1 has executed a sale deed during the pendings of the writ petition.
You go before the Deputy Commissioner, place all this material and obtain an order.
So meantime, the reserve may be right of the parties not to create a third party interest in respect of the property. Plus, during the pendings of the writ petition, he has executed a sale deed on 23 minutes. It is pending adjudication. Certain documents has not been placed before the sub-registrar officer.
See, that is why we have always been telling. You are only trying to play in the revenue courts or the survey before the survey authorities. When there are disputed questions of title, please go before the civil court. That
is true. I'll file necessary suit before the appellate court. That means during the pendings of these minutes, immediately they have been executed a sale deed minutes in the last month minutes, 2023.
So the scenario has become even more worse now. That the subsequent purchaser will now come on the basis of the sale deed. He will say, please enter my name. Can they refuse?
That is
or can they go into the question?
Pending.
So you please go.
Pending for registration. Pending for registration for requirement of certain documents minutes.
Learned senior counsel Shri M.S. Bhagwat, appearing on behalf of the petitioners, submits that the petitioners are calling in question the impugned order at annexure A dated 30/1/2023 purportedly passed by the Assistant Commissioner invoking Section 25 of the Karnataka Land Revenue Act of 1964 to review his own orders, set aside the same, recall the same, and issue fresh directions. Full stop. Learned Senior Counsel submits that the issue is no more res integra, that having regard to the provisions contained in Section 25 of the Act, this court, in the case of State of Karnataka versus Karnataka Appellate Tribunal, reported in AR 1996, Karnataka 143, has held that the inherent powers which are conferred on the revenue court definitely empowers the revenue court to review its own order, the order is palpably wrong and it suffers from error apparent on the face of the record, and that if the order is allowed to remain in operation, it may result in abuse of the process of the court, or it may result in miscarriage of justice. Stop. ನೀವು ಸೈಟ್ ಮಾಡಿದ್ದು?
2016 ILR 3275 Chandrasekhar Reddy versus State of Karnataka. Then one more judgment.
ಇಲ್ಲಿ ಯಾರು ಇಲ್ವಲ್ಲ ಸೈಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡೋದಕ್ಕೆ?
Yes, I'll pass over to your lordship. Lordship can note it. I'll give it to the court officer. Note it content. ILR 2016 Karnataka 3275.
230.
Yes.
My lord, there's one more order, my lordship only. ಅಲ್ಲ ಇನ್ನೊಂದಿದೆ, ಅದರಲ್ಲಿ 25 ಅಲ್ಲಿ ಓನ್ಲಿ ಎರರ್ ಆನ್ ದಿ ನ್ಯೂಮರಿಕಲ್ ಎರರ್ ಮಾತ್ರ ಕರೆಕ್ಟ್ ಮಾಡಬಹುದು, ರೆಫರ್ ಇಸ್ ನಾಟ್ ಅಂತ ಹೇಳಿ ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರೆಫರ್ ಮಾಡಿ, ಅದು ಐ ಗಿವ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಅವರು ತಂದ್ಕೊಡ್ತಾರೆ, ನೀವು ಕೊಡಿ.
ರೆವಿನ್ಯೂ ಅಥಾರಿಟಿ
Yes.
For petition in this case, my lord, there is a small correction, my lord, in writ petition, as evident from MR, my lord, the survey number 1/7 and 1/4 has to be included, my lord.
For correction of order.
Correction of order as well as writ
Dated
petition.
17/4/2023.
Yes, my lord. 1/7 and 1/4 has to be added. 1/7. Writ petitionally, Swami. Writ petitionally, we have stated 1/2, 1/8, 4/1 and 4/4 we have stated. Survey number. That has to be corrected as instead of 1/2, it has to be corrected as 1/7, my lord. And 1/4 has to be added.
ಎಲ್ಲಿದೆ?
In para 1 of the writ petition.
ಎಲ್ಲಿದೆ 1/7?
ಅಲ್ಲ 1/7 ಇಲ್ಲ, ಅದನ್ನ ಮ್ಯೂಟೇಶನ್ ಇದು MR ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಏನ್ ಹಾಕಿದೀವಿ annexure ಏನಲ್ಲಿ, it is reflecting, my lord, 1/7, 1/8, 1/4, 4/1, 4/4 ಅಂತ.
ನೀವೇ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ, ನಾನೇನ್ ಮಾಡ್ಲಿ?
ಅದು by oversight it has been not shown, my lord.
ಕರೆಕ್ಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಇವಾಗ. Let us see, you file an application, get it corrected and then we will see.
My lord, I have filed application, my lord. I have filed application, for the application only the matter got listed.
Notice has to be served on the other side. There is a contesting respondent. He will raise objection.
Lord,
Yes. Learned counsel for the petitioner is directed to serve a copy of IA number 1 of 2024 on learned counsel Sri KB Narayan Swami, who appears for respondent number 4. Yes.
my God, even there is an interim order and in that case, my
Interim
God,
order
because
granted earlier stands
no,
extended.
there is no extension, my Lord, there is absolutely,
Sorry,
but the problem.
ಅದನ್ನ ಕರೆಕ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ
Correction.
ನೀವು? Unless the other side gets an opportunity, we can't correct it.
Government, my Lord.
Contesting respondent ಇದಾರ್ರಿ ಬೇರೆಯವರು. Yes. Yes. For direction. ಏನಿದು?
My Lord, this writ petition is filed seeking the writ of Mandamus, my Lord. My Lord, one Venkatagowda is the original owner, my
To
Lord.
consider representation, ಏನಂತ?
My Lord, my grandfather is the owner of the property, my Lord. Even EC, encumbrance certificates reflecting the same, which is at annexure B1 to B5, which has been produced here, my Lord. Upon the same, in Tippani register, it has been stated that even my vendor's name is shown, my Lord. The revenue documents, all of a sudden, they have entered the name, they have shown below, classified the land as below.
15/10/1938. When one Venkatagowda sold the property in favor of Maiga Maistri.
Maiga Maistri. Yes, my Lord. He is the grandfather of the petitioner. My Lord, the land is in possession and title is in his name only. What has happened, my Lord, encumbrance certificates are standing in his name. All of encumbrance certificate.
Encumbrance started.
ಅದು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿದೆ encumbrance certificate.
Naturally, it will reflect.
Reflecting.
ಹೌದು.
The name of the grandfather's name is.
Was never entered in the land records.
It has now not entered in the land records, so it has been classified as a below.
Classified as?
Below.
Below.
Below. ಬೀಳು ಕ್ಲಾಸಿಫೈ ಆಗೋಗಿದೆ. ಈಗ ಅದನ್ನ ನನ್ಗೆ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಕೇಳಿ ನಾನು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಹಾಕಿದ್ದೀನಿ. I made a representation seeking my revenue record. But this representation has not been, they have given an endorsement stating that no documents available. Which is at annexure J and K, my Lord. They have given endorsement stating that no documents available concerning the land bearing survey number.
Then you are not challenging it.
I'm challenging it, my Lord.
But you are only asking for a writ of Mandamus.
My Lord, what has happened? Upon the same, I have sought for changing the kata in my favor.
They have already issued an endorsement. ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ.
ಅಲ್ಲ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಯಾವ್ದು ನಮ್ಮಲ್ಲಿ ದಾಖಲಾತಿಗಳು ಯಾವ್ದು ಇಲ್ಲ, ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ದಾಖಲಾತಿಗಳು ಯಾವ್ದು ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಅವ್ರು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದ್ರ ಮೇಲೆನೆ ನಾನು ಏನ್ ಮಾಡಿದೆ, ನಲ್ಲಿ ನಮ್ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ ಹೆಸರು ಇದೆ, ಸೊ ನನ್ ಖಾತಾ ನನ್ನ ಹೆಸರಿಗೆ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಐ ಹ್ಯಾವ್ ಗಿವನ್ ಅ ರೆಪ್ರೆಸೆಂಟೇಶನ್. ಈವನ್ ದಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬಿನ್ ಕನ್ಸಿಡರ್ಡ್, ಮೈ ಲಾರ್ಡ್. ಅಪಾನ್ ದ ಸೇಮ್ I filed this writ petition seeking a mandamus.
You please take instructions. ಹೌದು, but if there is a registered sale deed dated 15/10/1938, of course, we do not know why he did not get the name entered in the land records.
Even Tippani, in Tippani, there's my vendor's name.
The question is whether this Venkatagowda had the title to pass on to the purchaser. We do not know.
Tippani, the name of the vendor is showing. Tippani ಅಲ್ಲಿ ನಮ್ಮ ವೆಂಡರ್ ಹೆಸರು ತೋರಿಸ್ತಾ ಇದೆ. That annexure C.
RTC, they were given an RTC, which by the, they say 18/8/89 ಯಾರ ವರದಯ್ಯ ಅಂತ ಹೇಳಿ ವ್ಯಕ್ತಿ. And MR number 5 of 8089 put a copy of it. It says that his land was granted to the company.
So therefore, he'll have to challenge it. If the person who was executed the sale deed had no title, he can't pass it on to your grandfather.
My lord,
ಮತ್ತೆ ಅದನ್ನ ಕರೆಕ್ಟ್ ಆಗಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಡೋದು ಬೇಡವೇನ್ರಿ? ಈ ತರ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ರೆ they should say, no, according to our records, this person is the owner of the property and his name has been entered in the land records ಅಂತ ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
What we have only said in the entire RTC to the year 1968, 1984, it is not available. ಆಮೇಲಿಂದ 85 ಇಂದ ಇದೆ. MR 88, 89 ಅಲ್ಲಿ there is one transaction that has happened. What the MR register extract says is, this particular land was granted to one person by name Madaya. From there onward, the RTC reflects the name of Madaya.
So therefore, his application should have been rejected. How can you issue this endorsement? RTC ಬರೀ RTC ಕೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಅಲ್ಲ, ನಾನು RTC ಡೀಟೇಲ್ಸ್ ಕೇಳ್ತಾ ಇದೀನಿ. ನನ್ನ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಏನಿದೆ, ಹೆಂಗೆ ಬೀಳು ಅಂತ ಕನ್ಸಿಡರ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾನು ಡೀಟೇಲ್ಸ್ ಕೇಳ್ತಾ ಇದೀನಿ. ನಂಗೆ ರೆವಿನ್ಯೂ ಡಾಕ್ಯುಮೆಂಟ್.
Where is your representation?
My representation is that Annexure G, Annexure H and Annexure K to P. These are all my representation. Annexure G and H is the representation seeking my revenue document.
ಅದು
ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ
ಅದು ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. They have stated, I'll read out my lord. ಶ್ರೀ ಉದಯರಾಜು KN ಬಿನ್ ನಂಜಪ್ಪ ರವರು ದಿನಾಂಕ 13/1/2021
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
Annexure J is the endorsement.
Page number
29 my lord. Yes, my lord. ಶ್ರೀ ಉದಯರಾಜು KN ಬಿನ್ ನಂಜಪ್ಪ ಎಂ ರವರು ದಿನಾಂಕ 13/1/2021 ಅರ್ಜಿ ಕಾಲಿಂಗನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 65 5ರ MR RTC ನಕಲು ಕೋರಿದ್ದು ಸದರಿ 1984 ರಿಂದ 87ರ ಸಾಲಿನಲ್ಲಿ ವಹಿಯ ಲಭ್ಯವಿಲ್ಲದ ಕಾರಣ RTC 1984-87ಕ್ಕೆ ಅಂತ್ಯವಾಗಿರುವುದರಿಂದ ನೀವು ಕೇಳಿರುವ ನಕಲು ನೀಡಲು ರಾಹವಿಲ್ಲದ ಕಾರಣ ನಿಮ್ಮ ಅರ್ಜಿಯನ್ನು ವಿಲೆ ಇಡಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಿದೆ. This is what the endorsement they have given, my lord. There is no document stating there is no document. Even Annexure K, even they say the same thing.
What did you seek for?
My lord, the same document.
document?
RTC. RTC, Swami.
RTC for
same survey number 65ಕ್ಕೆ.
ನಿಮ್ದು ಇವಾಗ ಲೇಟೆಸ್ಟ್ RTC ಇದೆಯಾ ಅಲ್ಲಿ?
Subsequently from the date of grant,
that person's name has been continued in the RTC?
Madaya.
ಕಂಟಿನ್ಯೂ ಆಗಿದೆಯಾ?
ನಮ್ಗೆ ಅದು ಯಾವ್ದು ಕಾಪಿನೇ ಸಿಕ್ಕಿಲ್ಲ ಸ್ವಾಮಿ. ಕಾಪಿ ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ. ಅದು ಯಾವ್ದು ನಾವು RTC ಕೇಳ್ಕೊಂಡೆ ನಾವು ಇದಾಕಿದೀವಿ. ನಮ್ಗೆ ಯಾವ್ದು RTCs ಕೊಟ್ಟಿಲ್ಲ. ನನ್ನ ಹತ್ರ ಇಂಡೆಕ್ಸ್ ಇದೆ. ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಸರ್ಕಾರಿ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ಬೇರೆ ಯಾವ್ದು ಮಾಹಿತಿ ಇಲ್ಲ.
2000ಗೆ ಚೇಂಜ್ ಆಗ್ತದೆ. ಸರ್ಕಾರಿ ಅಂತ ಬಂತು, ಸರ್ಕಾರ ಅಂತ ಬೀಳು ಅಂತ ಬಂತು. ಫ್ರಮ್ 1988 to 99-2000 ವರೆಗೂ ವರದಯ್ಯ ಅಂತ ಬಂದಿದೆ. From 2000 onwards ಸರ್ಕಾರ ಅಂತ ಬಂದಿದೆ.
That person also is not challenged.
ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ?
Annexures L, M, N, P. What are you asking in all this representation? If you are asking only for certified copies of the RTC, whatever is available, you give it.
ಅಲ್ಲ, ಆ ಏರಿದ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ನಾಟ್ ಪ್ಲೀಸ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅದೇ Annexure K page 30. Page 30 ಹ್ಯಾಂಡ್ ರಿಟರ್ನ್ ಇದೆ. ಅಭಿಲಾಯ ಶಾಖೆಯ ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು ಬೇಳೂರು ಹೋಬಳಿ
representation dated 4/12/2021 ಗೆ an endorsement has been issued. 4/12/2021 at annexure L.
Yes, ma'am.
ಅದಕ್ಕೂ issue ಮಾಡಿಲ್ಲ.
issue ಮಾಡಿದ್ದೀವಿ. ಅದು the previous pages. They have asked only for articles in the year 1968 to 1984. 1968 ಇಂದ 1984 ವರೆಗೂ ಕೊಡಿ ಅಂತ ಕೇಳಿ. ಅದಕ್ಕೆ issue ಮಾಡಿದ್ದೀವಿ. We say that it is not available. The previous page. Page 30 annexure K. He is not artificial. Now, the latest annexure L ಅಲ್ಲಿ therefore all these other documents. ಬೇರೆ ಇದೆಲ್ಲ 88 ಇಂದ ಕೊಡಿ. Page 39 ಹೇಳ್ತಾರೆ. RTC pertaining to period 1988 to 2000. Adala latest, this is the latest representation they have given.
They are only asking for certified copies of the RTCs. Ashte, nothing else.
Page 39 note. Page 39 madam. Conclusion part alli what are the documents they want to know? As per RTC pertaining.
I requested to make necessary changes in the preliminary index of records and index of land and RTC. Nan changes ಕೇಳಿದೀನಿ ಸ್ವಾಮಿ. I have asked for changes upon the representation which I have made. ನನ್ನ ಹೆಸರಲ್ಲಿ documents reflect ಆಗ್ತಾ ಇದೆ. Upon the same, I have asked for changing the index of records, index of land, RTC. So I may be permitted to read page number 39. I'll read. Yes, ma'am. Conclusion, the status of the land measuring 2 acres 32 guntas east by government land, west by government land, north by government land, south by government land under survey number 65 belongs to Mandamus and duly registered with sub-register office of sub-register Nagamangala 15/10/1938 without any gazette notification, government orders, paper publication or concurrence of sub-registrar's office Nagamangala, no intimation to Katedar regarding acquiring of the land of 2 acres survey number 65 had been modified as following during the period of 1938 to 22. As per the RTC pertaining to the period of 1988 to 2000, a portion of land measuring 1 acre shown in the name of Vardaya. This has been, I have disclosed it. As per the RTC pertaining to the period of 2000-2002, and land shown as Sarkari without any change in the area of land 2 acres 32 guntas, which is mentioned in the original absolute sale deed. Copy of the dated 15/10/1938. As per the computerized RTC pertaining to the period of 2002 to 2022, again the land as shown as Sarkari without any change regarding the original land area of 2 acres 32 guntas. In view of the facts explained above, I request your good office to consult original sale deed dated 15/10/1938 as well as the incumbency certificate for the period of 1938 to till date and land of 2 acres 32 guntas under survey number 65 at Kalinganahalli village, Beduru Hubli, Nagamangala Taluk, where the name of the owner is mentioned as Sri Maiga Mesri. Hence, it is requested to make necessary changes in the preliminary index of records, index of land, and RTC issue fresh corrected documents.
You have given to assistant commissioner. File an appeal under section 132. They will consider. Berkeley.
Well, at least they should have.
You will have to file an appeal, sir. ನೀವು ಸುಮ್ಮನೆ ಬರೀ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೇಳೋದ್ರಲ್ಲಿ ಏನು ಪ್ರಯೋಜನ ಇಲ್ಲ.
At least they have.
You find that some other name has been entered in the RTC, name of the government has been entered in the RTC, you will have to challenge it in a manner known to law. What is the use of simply asking for giving certificate copies?
Well, revenue records, they have to give the revenue records during for the period which I have asked for.
ನಿಮ್ಮ ಹೆಸರು ಎಂಟರ್ ಆಗಿಲ್ಲ. Whoever has purchased, the name was never entered. Now the name of the government is standing in the records. You will have to challenge it. Please challenge it by filing an appeal under section 136.
Tippani.
They will give all the information.
Well, Tippani showing the vendor's name, vendor name of.
ಇರ್ಬೋದು. I'll pass orders at 2:30.
Yes, Lord, I have the register. Lord. I have the register.
ಮುಗಿಸ್ಕೊಂಡು ಬನ್ನಿ ಆಮೇಲೆ ನೋಡೋಣ. When he is saying is it is ready, why should we unnecessarily adjourn the matter? ನೋಡ್ಕೊಂಡು. Yes.
Serial number 39, how to go to hospital.
It can't be adjourned now, sir.
It's not
We will
for
see.
adjournment. For recalling of dismissal order.
ಇವಾಗ ಏನ್ ಮಾಡ್ಲಿ ನಾನು?
I have to go to hospital.
ವಕೀಲ್ರೆ ಸ್ವಲ್ಪ ಕೊಡಿ ಸರ್ ನಿಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ತೀನಿ. ಸರ್ ಲೆಟ್ ಮಿ ಸಿ.
ಎಲ್ಲ ಅರ್ಧೋಗಿದೆ ಸರ್.
ಅರ್ಧೋಗಿದೆ ಸೊ ನನ್ಗೆ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ ಮೇಲೆ. I should know. I should know. ಯಾಕಂದ್ರೆ ಸಾಹೇಬ್ರು ಕೊಡ್ತೀರಿ ನನ್ಗೇನ್ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್? ಸಾಹೇಬ್ರು ಕೊಡ್ತೀರಿ ನಾನ್ ಹೇಗ್ ಮಾಡೋದು? ಕೊಡಿ 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 ಕೊಡ್ರಿ. ನಮ್ದು ಬಿಟ್ಟು
ಮೆಮೊ ಹಾಕಿದ್ರು ಮೊನ್ನೆ ಒಂದೇ ಮೆಟ್ರೋ ಇರುತ್ತೆ. ಹೌದು, ಅದು ಕೋರ್ಟ್ ಫೀ ಲೆಕ್ಕದಲ್ಲಿ 2 ನಂಬರ್ ಆಗಿರುವಂತ. ಹೌದು 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 ಒಂದೇ ಇರೋದು. ಅವ್ರು ಮೊನ್ನೆ ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ರು.
ಪಾಸ್ವರ್ಡ್ ಬೇಡ. ಪಾಸ್ವರ್ಡ್ 2 ಇದೆ ಮಧ್ಯಾಹ್ನ. ಮಧ್ಯಾಹ್ನ ಸೀರಿಯಲ್ ನಂಬರ್
10. Put red pen.
ಅಲ್ಲಿ ಕರೀತಾರೆ ಅಲ್ವಾ ಮೇಲೆ ಅಲ್ಲಿ ಫೋಟೋಸ್ ಹೇಳಿ ಕರೀತಾರೆ ಮಾತಾಡೋಣ ಗೊತ್ತಾಯ್ತಲ್ಲ
ಫೋಟೋ ಕೂಡ ಅಲ್ಲೇ ಸಾಹೇಬ್ರು ಬರುತ್ತೆ ಇನ್ನೂ ರೆಡಿ ಮಾಡಿಲ್ಲ ಎರಡು ವೈಫೈ ಇಲ್ಲ ಅದು ಸಾಹೇಬ್ರಿಗೆ ಕ್ಯಾಮ್ರಾ
ಬರ್ತೀನಿ ಮೇಡಮ್. ಇಲ್ಲ.
Too late. It's done. Amendment. Amendment first. Let's screen ಮಾಡ್ಕೊಡ್ತೀನಿ. One submission ಮಾಡ್ಬಿಟ್ರೆ 10 ನಿಮಿಷ ನಡೆಯುತ್ತೆ. citation ಇಲ್ವಲ್ಲ, ನಿಮ್ಮಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಹೇಳ್ಕೊಡಕ್ಕೆ, ಒಂದು ಕೆಲಸ ಮಾಡಿ ನೀವೇ ಬಂದ್ಬಿಡಿ ಅಂತ ನಾನೊಬ್ಳೆ ಹೋಗಂತ ಹೇಳಿ ನಾನು ಬರ್ತೇನೆ. ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ.
ಏನು ಏನಿದೆ? 25 ತಕ್ಕೋ, ಸೆಕ್ಷನ್ 25 ತೆಗಿಯಮ್ಮ. ಇದು ಕೈಲಿ ಬಿಡ, ಮತ್ತೆ ಒಳಗೆ ನೀನ್ ಜವಾಬ್ದಾರಿ ಇಲ್ಲ, ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಒಂದು ಕಳ್ಕೊಂಡು ಹೋಗಿದ್ದೇನೆ. ಅಡಿಗೆ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಬೇಡ.
ನಾನು ವಾಶ್ರೂಮ್ ರೀಚ್ ಆಗಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಇಟ್ಟಿದೆ ಪೆನ್ನು ಕೊಟ್ಟಿದೆ.
Pronouncement being spoken to the. Zero 716. Being spoken to. ಆಯ್ತು ನೋಡಿ. ಎಲ್ಲಿ being spoken to? ಯಾಕೆ ಕೊಟ್ಟಿದ್ದು? ಆರ್ಡರ್ ಇದು ಕೊಟ್ರ ಇದು announcement ಅಲ್ವಾ ಫಸ್ಟ್ ಫಸ್ಟ್ announcement.
ಕಳ್ಸಿದ್ದಾರೆ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನಿದೆ 24 ಡೇಸ್ ಬಂದಿದ್ದಾರೆ ಅಷ್ಟು ತರ್ಸ್ಕೊಂಡು ನಾನು ಹೇಳ್ತೀನಿ ಸೋಮವಾರದಿಂದ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಫಸ್ಟ್ ಆಮೇಲೆ ಇದು ನಾಳೆ 2:30 ಮತ್ತು ಡಿಫ್ರೆಂಟ್ ಡಿಸೆಂಬರ್ 2 ಮಾಡೋಣ
ಅವ್ರದ್ದೆಲ್ಲ ಮಾಮೂಲಿ ತಾನೆ ಕಾಫಿ ಹೋಗುತ್ತೆ. ತಗೊಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಅಲ್ಲ 38 ಬಂದು 38 ಕಂಟಿನ್ಯೂಷನ್ ಮಾಡೋಣ ಅಂತ ಹೇಳಿದ್ರು. 38 ನಮಗೆ look at me he made call. ಇದೆ ಪ್ರಾಬ್ಲಮ್ಸ್ ಕಂಡಿದೆ ಅದನ್ನ ಅಷ್ಟೇ ಇಂಡಿವಿಜುವಲ್ ಮಾಡ್ತಾರೆ ಸರ್. ಅದೆಷ್ಟು ಇವತ್ತೆಲ್ಲ ನಾವು ರೀಚ್ ಆಗಿದೆ ಎಲ್ಲ ಫುಲ್ ರೀಚ್ ಆಗ್ತದೆ ರೀಚ್ passport passport experience ಎರಡು ಒಂದು ಇಷ್ಟು ಕನ್ಫರ್ಟ್ ಆಗುತ್ತೆ.
ನಾನು ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ನೀನು 40 ಆಯ್ತಲ್ಲ ಚೇಂಬರ್ ಎಲ್ಲ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Announcement of orders at 2:30 PM matter. Serial number 48, AM Shodhan Babu.
Consequently, this court proceeds to pass the following order. Writ petitions number 6546 of 2023 and 6550 of 2023 are dismissed. Writ petitions number 11271 and 11272 are allowed, while setting aside condition number 7 imposed in their respective government order.
Continuation. Serial number 38, KV Narasimhan.
My lord, representation was made to Tahsildar, even Tahsildar it has been made.
Audrey, you are going on making representations after, for what purpose?
My lord, at least the
You
Tahsildar,
know your name are not the person from whom you are claiming, trying to claim title,
Yes, my lord.
his name is not found in the RTC.
Yes, my lord.
The name of this government is now found in the RTC.
Yes, my lord.
You will have to question in a manner known to law. What is the use of giving representations after representations? Merkel.
At least Tahsildar may give, at least Tahsildar may let directed to give at least endorsement, my lord, upon my.
ಏನ್ endorsement?
ಈ ಜಾಗ ಏನಕ್ಕೆ ಸರ್ಕಾರಿ ಆಯ್ತು ಅಂತ ಫಸ್ಟ್ ಬೀಳು ಅಂತ ಆಯ್ತು, ಬೀಳು ಅಂತ ಆದ್ಮೇಲೆ ವರದರಾಜ್ಯಗೆ ಹೋಯ್ತು, ಆಮೇಲೆ ವರದರಾಜ್ಯ ಅಂತೇಳಿ ಎಂಟ್ರಿ ಆಯ್ತು, ಆಮೇಲೆ ವರದರಾಜ್ಯ.
Which provision is to give all this information to you?
My lord, at least.
Under which provision, sir?
My lord, I've made a representation, my lord, at least.
Adene, you are only trying to fish information from him. Allah agadilla. If you have a right, you will have to establish and say, this is why my name has to be entered. Go give the information and challenge it. The petitioner is seeking a writ of Mandamus directing the respondent, Tahsildar, Nagamangala Taluk, and the Assistant Commissioner, Pandavpura Subdivision, to consider his representations dated 4/12/2021, 4/6/2022, 25/2/2023, and 27/3/2023. Full stop. Next paragraph. It is the contention of the petitioner that two acres and 32 quintals of land in survey number 65 of Kalinganahalli, Pelluru Hobli, Nagamangala Taluk, originally belonged to one Venkategowda, son of Timmegowda. Full stop. It is contended that the grandfather of the petitioner, Sri Maiga Maistri, Maistry, purchased the lands from Sri Venkategowda under registered sale deed dated 15/10/1938. Full stop. It is contended that the earliest available land records, namely the reclassification tippani concerning the land in question, contains the name of the petitioner's grandfather. Full stop. However, it appears that thereafter the land has been classified as Bilu. Full stop. The petitioner has given several representations earlier too. Full stop. The petitioner has furnished two endorsements issued by the Tahsildar, one at annexure J and another at annexure K. Full stop. Learned AGA submits that in terms of the earlier representation given by the petitioner, the Tahsildar has disposed of the representation, stating that the RTCs sought by the petitioner for the year 1984 to 1987 is not available. Full stop. At annexure K, it is stated that after verification of the records, it is found that the RTCs for the year 1968 to 1984
Are not available.
are not available, and therefore a copy of the same as sought by the petitioner cannot be given. Full stop. Next para. Having pursued the representations given by the petitioner, this court finds that the petitioner is once again seeking the same information and further the petitioner is seeking removal of the name government from the land records and to show the name of the
Petition.
show the name of the grandfather of the petitioner who had purchased the land under registered sale deed dated 15/10/1938. Full stop. It is also seen that the petitioner himself is aware of the fact that in the RTCs pertaining to the year 1988 to 2000, the name of one Sri Varadaya was reflected. Full stop. Thereafter, the name of government is shown in the RTC. Full stop. Next para. Therefore, if the petitioner seeks to have the name of his grandfather entered in the RTC on the strength of a registered sale deed, while it is evident from the RTC that the name of government finds place in column number 9, then the petitioner will have to take action in accordance with law. Full stop. It will be a futile exercise going on giving representations to the Tahsildar and the Assistant Commissioner. Full stop. Next para. With these observations, the writ petition stands disposed of. Number 2. Yeah, so
Passed over.
dictation ಅರ್ಧಕ್ಕೆ ನಿಲ್ಸಿದ್ವಲ್ಲ.
Passed over matter. Number 36. Till number 36.
The first two judgments are not, if inherent power, review cannot be exercised. under Supreme Court judgment 2019. The last two judgments are section 25 order. Naresh Kumar and others was the government of NCT Delhi. Supreme Court examined whether inherent power, can they exercise the power of review?
Yes.
Supreme Court said no.
Yes.
Second judgment, that is under the Land Acquisition Act.
It can be exercised only when statute provides for the same expressly.
Yes.
Specifically, or by necessary implication.
Yes.
In absence of any such provision in statute concerned, power of review cannot be exercised in case of judicial, quasi-judicial orders. Exercise of power of review in absence of express provision would be ultra vires, illegal and without jurisdiction.
Second judgment is also not under the Industrial Tribunal Act 1947. Whether Industrial Tribunal has power to review when there is no specific power. Court said no. The third judgment is, my lord, Land Revenue Act of our High Court. There, my lord, court examined that. My lord will find reference para 15, page 30. Chandrasekhar Reddy. Then court refers para 17 and 18. Ultimately says Assistant Commissioner has no power of review. The last judgment is, my lord, also section 25, para 6, my lord will find page 38. There, my lord, Deputy Commissioner has exercised the power of review. Para 6, my lord will find facts referring to sections 25 and 15 of Karnataka Land Revenue Act. Court ultimately come to conclude, my lord, under section 25 of the Land Revenue Act, Deputy Commissioner has no power of review. Accordingly, my lord, para 6 only. Legal representative, the original grantee, respondent 3A to C, page 38. Approach the Deputy Commissioner, again filing a petition under section 151 of seeking a review of the order on 27/9/2012. By the impugned order passed on 29, Deputy Commissioner exercised the power allegedly vested him under section 25, read with 59 of the Karnataka Land Revenue Act, and has recalled the order dated 27/9/2012. In the last portion of the impugned annexure B, Deputy Commissioner further states that matter has been taken up for review under section 25, read with section 59 of the Karnataka Land Revenue Act, and case was posted up for hearing 9. Ultimately, concluded review has power to review doesn't lie. Para 14 conclusion and 15. That's all. I think there's one judgment I saw in the file. My lord has also passed the order.
ಯಾವ್ದು ನನ್ನ ಆರ್ಡರ್
ಅಲ್ಲೇ ಫೈಲ್ ಲಾಸ್ಟ್ ಇದೆ ಫೈಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ತಗೊಳ್ಳಿಕ್ಕೆ ನೋಡಿದ್ರು ಅವಾಗ ತಮ್ಮ ಆರ್ಡರ್ ಇದ್ದಂಗೆ ಕಾಣ್ತು ನನಗೆ. ಅಲ್ಲಿ ತಮ್ಮದೇ ಇರಬೇಕು. ಫೈಲಲ್ಲೇ ಇತ್ತು.
ಇಲ್ಲ, ಯು ಆರ್ ರೆಫರಿಂಗ್ ಟು ಒನ್ ಮೋರ್.
ಅಲ್ಲ, ಒನ್ ಮೋರ್ ಕೊಡ್ತೀನಿ.
ತಾವು 96 ILR KLJ ರೆಫರ್ ಮಾಡಬಾರ್ದು.
ಇದರಲ್ಲಿ ಇಲ್ಲ ಸರ್, ಕ್ಲಿಯರ್ ಆಗಿಲ್ಲ. ಕ್ಲಿಯರ್
ನಂಬರ್ ಹೇಳಿ. ಔಟ್ ಆಫ್ ಸರ್. WP 20
40013
18. Oh. No. 4013 of 18.
ಇದಲ್ಲಪ್ಪ. Yes. What do you have to say?
Let's what my learners has placed materials on minutes. The third judgment, which is para number 6 minutes. Para number 6 and third judgment, I think so, page number 34 minutes. Para number 6 and
ಯಾವ್ದು?
The
last
page number
judgment.
38 minutes.
ಯಾವ್ದು?
Ink page number 38, last judgment. Last judgment. The original grantee in respect of this so here is approach the deputy commissioner against the filing the petition under section 151 of seeking a review of the order passed on 27/9/2022
number
by
38.
including order. 38, ink page number 38.
Paragraph?
Paragraph 6. That's it is made specific clear minutes.
Yes.
The grantee of respond number 3 and as here and approach the deputy commissioner again the filing application under section 151 of seeking a review of the order not under section 225 minutes. Review of the order passed by him on 27/9/2012 by impugned order passed on 25/10/2012. The deputy commissioner has exercised the power allegedly vested him under section 25 read with section 59 of Karnataka Land Revenue Act 1964. I recall the order on 27/9/2022. The last portion of the impugned order shall be deputy commissioner further state that the matter has been taken up for review under section 25 read with section 50 of the Karnataka Land Revenue Act. Same case is posted for hearing. There was no findings and given by these things. And para number 14 also made it clear. That was not decided. And as an already averted above, the petitioner, while filing the appeal before the deputy commissioner, had made a specific grievances that without including him, assistant commissioner as a passed an order directing to resumption of the restoration of the land purchased by him. In fact, the grievance has been referred by the deputy commissioner in his order as stated how he was affected the person could maintain the appeal challenging the order assistant commissioner. Therefore,
No finding
without
is
there
given.
being
No finding is given about that one.
and also, this is the only grievance that has been made before the different court. Those who are not a parties before the assistant commissioner. The year is that the order, the whatever order has been passed by the assistant commissioner is totally different.
What do you have to say about the judgment of the Honorable Supreme Court? The first one. Review is not inherent power.
It can be exercised only when the statute provides for the same
Expressly.
specifically or by necessary implication in the absence of any such provision. In absence of any such provisions in statute and consent, the power of review cannot be exercised in the state of judicial quasi-judicial orders. Exercise the power of the review of the absence of any express provisions would be ultra vires illegal without any jurisdiction.
Paragraph 8 what is?
There is no provision in the Land Acquisition Act for review of the award and pass under section 7 of the act of the attend the penalty of the only provisions for the corrections of the clerical errors of the award which has been provided under section 13A of the act. The insert under the effect of the from 24/9/1984, the relevant of section 13A and the act is reads as under 13A. Correction of clerical errors of the collector may at any time but not clear within the 6 months from the date of the award. Where has been acquired by the section 18 of the make it reference to the court before making any such reference. By order correct any clerical and authentical mistakes in the award. And error arising therein its own motion or in the application of any circumstances in the local authority. Provided no corrections which is likely to be affected prejudicially in persons shall be made unless the person has been given a reasonable opportunity to making a presentation in the matter. The collector shall have given immediate notice to corrections made to avoid all the persons interested. And where the excess of amount is provided for the being is paid when the person as in result to corrections is made under the subsequent to excess amount to be paid shall be liable to be refunded in the case of any default of refusal to pay the same has been recovered upon. What is this?
The
Here
learned
is
senior
that
counsel submits. The learned senior counsel seeks to place reliance on a judgment of the Honorable Supreme Court in the case of Naresh Kumar and others versus government, bracketally NCT of Delhi, close. Reported in 2019, close. 9 SCC 416. To, in support of his contention that section 25 will not enable a review of an order passed by the authority. Full stop. Next paragraph.
The second judgment, my lord. Page 16, para 19. Where, my lord, power of review is not there, industrial tribunal reviewed the order. Then Supreme Court says, my lord, this. They referring to the para 18 judgment of the various courts. Applying this principle, it is apparent where a court or quasi-judicial authority having jurisdiction to adjudicate on merit proceed to do so, its judgment or order can be reviewed on merit only if the court or quasi-judicial authority is vested with the power of review by express provision or by necessary implication. Procedural review belongs to different category, etc. In such a review, quasi-judicial authority having jurisdiction to adjudicate it proceed to do so, doing so commits root of the matter, invalidating proceeding itself. Consequently, order passed there in cases where decision rendered by a court or quasi-judicial authority without notice to own funds. So unless there is an express provision, power of review is not there.
Further, in the case of further in another decision of the Honorable Supreme Court, in the case of Karpa Mazdoor Ekta Union versus Birla Cotton Spinning and Weaving Mills Limited, and another bracket 2005 close 13 SCC 777. It has been held that where a court or quasi-judicial authority having jurisdiction to adjudicate on merit proceeds to do so, its judgment or order can be reviewed on merit only if the court or the quasi-judicial authority is vested with power of review by express provision or by necessary implication. Full stop. Next para. Per contra, learned counsel for the contesting respondents seeks to submit that after the orders were passed by the Assistant Commissioner, this court, in a contempt petition in in civil contempt petition number 251 of 2022, and the division bench, this court had passed an order on 1st of December 2023, taking note of the memo submitted by the learned additional government advocate stating that the PODI records were rectified in terms of the directions issued by this court. And accordingly, the contempt petition was disposed of. This aspect of the matter had to be brought to the notice of the Assistant Commissioner, and therefore the contesting respondent herein filed the application invoking section 25 of the Karnataka Land Revenue Act, 1964. Full stop. Next para. The question therefore is whether the petitioner, the contesting respondent herein could have sought for a recall and review of the orders earlier passed by the Assistant Commissioner under section 25 of the Act. Full stop. Next para. Section 25. Of the Act reads as follows, extract not. Next para. Having regard to the law laid down by the Honorable Supreme Court in the two judgments cited by the learned senior counsel, it is clear that quasi-judicial authorities are not permitted to review their orders unless such powers are expressly vested in them in the statute. We'll stop. The provision only enables the revenue authorities to invoke the inherent power to make such orders as may be necessary for the ends of justice or to prevent the abuse of the process of the revenue court. Full stop. This court is therefore of the considered opinion that the provision does not expressly provide for review of an order passed by the revenue authorities. Full stop. In that view of the matter, the impugned order passed by the Assistant Commissioner cannot be sustained. Full stop. On the other hand, it is always open for the contesting respondents herein to seek revision of the order passed by the Assistant Commissioner while placing before the revisional authority the subsequent developments and any orders that are passed by this court or any competent authority which would enable the revisional authority to reconsider the case of the contesting respondent here. Full stop. Next para. Consequently, the petition is allowed. The impugned order, Annexure A, passed by the Assistant Commissioner, Bangalore North Subdivision, invoking section 25 of the Karnataka Land Revenue Act, 1964, is hereby quashed and set aside. Full stop. Ordered accordingly.
Liberty may kindly reserve to respond number contesting respond. Meanwhile, they are trying to alienate the property minutes. Meanwhile, minutes they are
Adalla
sale. During the appeal period,
ಅಲ್ಲ, ಇಲ್ಲಿ
meanwhile,
ಮಾಡಕ್ಕಾಗೋದಿಲ್ಲ.
they're taking advantage of the order, my lords, they're trying to alienate the property.
How
my
will
lords.
they alienate only because the revenue entries are changed?
In
Yes.
fact, my lords, the sale deed has been created already, my lords. That is the only reason which I have been.
ಏನ್ ಹೇಳೋದು?
That is what, my lords, still such a matter
ಏನ್
to
ಮಾಡೋದು?
file. my lords.
ಈಗಾಗ್ಲೇ ಆಗೋಗಿದೆಯಲ್ಲ.
ಅಲ್ಲ ಆಗಿದೆ ಅಂದ್ರೆ it is pending for registration, my lords. Pending registration, my lords. Therefore, my lords, I request made before
This court can take note of that one and pass any order?
not like that.
ಎಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
At least till my lords appeal filing appeal period, my lords, let the further consequences, whatever the order has been filed. Further consequences of this order, my lords, shall not be take advantage of this, my lords, alienate the property, my lords, taking advantage.
ಆಗೋಗಿದೆಯಪ್ಪ ರಿಜಿಸ್ಟ್ರೇಷನ್.
ಅಲ್ಲ ಆಗಿಲ್ಲ, pending registration, my lords. It is pending registration.
Serial number 10, pass over matter. Pass over matter. Serial number 10,
I pay for the petition.
Karnataka appeal.
ಇವಾಗ ನಾವು ಮಾಡಿದ್ದು 38.
Yes, annexure A is the order which is challenged, my lord, wherein the grant made in favor of the petitioner, which was in the year 1994, my lord, Sagole Ch-8 was issued. That has been set aside. 1994, there was a Sagole Ch-8 issued in favor of the petitioner, as per annexure B, my lord. That was challenged in the year 2001, 2002. That was a complaint was filed by the fourth respondent hearing.
RA 2003, 2004.
ಹೌದು. RA ಹೌದು. ಅದರಲ್ಲೂ the appeal is 50/2001, 2002. Without filing any condonation of delay application. That one, the fourth respondent, who is not even an applicant and not a rival claimant, files an complaint or appeal against the grant made in favor of the petitioner. After holding inquiry, my lord, the assistant commissioner passes an order setting aside my Sagole Ch-8. This was challenged in RA 53 of 2003, 2004. That was also dismissed. Later, my lord, the petitioner filed a revision petition before the K-80 and
Under rule 108, D6.
D6.
Oh, D6.
K-80 has remanded the matter for fresh inquiry by the assistant commissioner. The proceeding was, my lord, dismissed for non-prosecution.
K-80 na?
Allah, K-80, the petitioner approached the K-80.
What did the assistant commissioner do?
He sets aside the grant.
Grant.
That was challenged in appeal before deputy commissioner. He also confirmed the order. The petitioner approaches K-80 and K-80 sets aside both the orders and remands the matter to fresh inquiry before the assistant commissioner. Assistant commissioner, my lord, as I have produced the order sheet at page number 33. Since the complainant or the petitioner and the respondent absent, the proceedings continuously, hence the case is dismissed anta ಮಾಡ್ತಾರೆ. And again, it was not restored again. And on 30/11/2020, again both ಅಂದ್ರೆ ಅಲ್ಲಿ ನೋಟ್ ಬರೀತಾರೆ, ಪ್ರಕರಣದಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದು ಸಂಬಂಧಿಸಿದ ನ್ಯಾಯವಾದಿಗಳಿಗೆ ಮಾಹಿತಿ ತಲುಪಿರುವುದಿಲ್ಲ, ಆದ್ದರಿಂದ ಪುನಃ ನೋಟಿಸ್ ಮಾಡಿದೆ. ಅವತ್ತು again both appellant and respondent absent continuously for sufficient reason. Hence the case is dismissed. First one was dismissed.
So it was recalled on the same day.
Alla, not recalled.
30/11/2020, it was recalled on the same day.
ಹೌದು.
Yes.
Before that 30/10 ಹೌದು. And passes an order on merit at annexure A.
After hearing you, isn't it?
No, without hearing. Both the parties were absent.
2021.
ಹೌದು. ಅಲ್ಲಿ ಮಾಡಿಬಿಟ್ಟು Sagole Ch-8 was set aside. Because my submission is that, my lord, the fourth respondent
2021.
ಹೌದು.
That you are challenging now.
21 ಹೌದು.
You are challenging it now.
Without knowledge, my lord, that was set aside. But my grant was in the year 1994 itself, my lord. That was challenged in the year 2001 by the fourth respondent, who was not a rival claimant.
ಏನಾಗಿದೆ ಅದಾದ್ಮೇಲೆ your name has been removed?
Yes, my lord.
ಇದೇ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಯಾರೆ, ಗ್ರಾಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಯಾರೆ.
ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ಮೇಲೆ
ಸರ್ಕಾರ ಬರೀ
ಸರ್ಕಾರ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಸರ್ಕಾರ ಅಂತ ಮಾಡಿ ಅಂತ ಹೇಳಿ.
Learned the AGA takes notice for response number 1 to 3. Issue notice to respond number 4. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Early known. There is a huge delay.
ಅಲ್ಲ 2020 ಸ್ಟೇ ಆಫ್ ದಿ ಆರ್ಡರ್ ಕೊಟ್ರೆ ಇಲ್ಲ ಇದ್ರೆ ನಮ್ಮನ್ನು ಡಿಸ್ಪೋಸಸ್ ಮಾಡಿ ಬಿಡ್ತಾರೆ. ಡಿಸ್ಪೋಸಸ್ ಮಾಡಿ
21. There is a long delay. You will have to explain.
ಅಲ್ಲ
Yes.
List number 2. Serial number 1, Lakshmikant K. FF. Emergency notice RC first. 3 to 11.
Furnishing a process fee. Response number 3 to 11. Finally, 2 weeks time is granted to the petitioners to take steps to furnish the correct address and take steps for service of notice on response number 3 to 11.
Number 2, Kevin Narasimhan. Notice. Here.
For petition. Await service of emergency.
Await illa. You will have to take steps.
Yes, madam.
A week's time is granted at the request of learned counsel for petitioner to furnish the correct address and take steps for service of notice on the unserved respondents. 2 weeks on somebody. Yes.
Interim order action.
Interim order granted earlier stands extended till the next date of hearing.
Serial number 3, Vardarajan MS.
Notice sought against the respondent number 3 grant. Therefore, notice to respondent number 3 may be dispensed with. Respondent number 3. Maybe notice may be dispensed with.
Why?
Because my lord, the respondent number 3 also one of the family member of the petitioner, my lord. At the time of
Learned counsel for the petitioner has filed a memo dated 6/3/2024 in all these writ petitions stating that no relief is sought against respondent number 3 and therefore notice to respondent number 3 may be dispensed with. Full stop. The memo is taken on record subject to all just exceptions. Full stop. The learned counsel for the petitioner further submits that respondent number 3 is the family member of the petitioner. And therefore, no relief is sought against respondent number 3. Full stop. Next para. At the risk of the petitioners, notice to respondent number 3 is dispensed with.
Yes, 3.4, very same party, respondent number 8. The serial number 3.4, my lord. ಅದರಲ್ಲೂ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 8 ಅಂತ ಆಗ್ಬೋದು. ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ? ಎಂಟ್ರಿ ಮಾಡಬೇಕು.
ಇನ್ನೊಂದು ಪ್ಯಾರಾ ಮಾಡಿಕೊಂಡು in WP number 18817 of 2022, respondent number 3 is shown as respondent number 8.
No, respondent 8 mean. Respondent 8 correct mean. Respondent 8 very same party.
ಅವ್ರ ಬೇರೆನಾ?
ಅಲ್ಲ ಅವರೇ ಇದರಲ್ಲಿ respondent
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದ್ರಿ. Respondent number 3 is shown as respondent number 8.
Please.
And therefore the relief, the dispensation of notice in the said petition is sought against respondent number 8. Yes.
Entry ಮಾಡಬೇಕು.
Interim order granted earlier stands extended till next date of hearing.
Serial number 4, SV Prakash.
At the office, correct address and PM.
You will furnish it today.
Yes, yes. Today one.
It is furnished. You already furnished.
Yes.
Learned counsel for the petitioner submits that the needful has been done.
Yes.
Office to verify and issue notice.
Yeah, I will. Interim order will be extended.
Interim order granted earlier stands extended till next date of hearing.
In next matter also same.
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 Yes. 5 also same.
Serial number 6, Kimrayappa DC, FEF R4 second time.
Same order, 2 weeks. Correct address and taking steps.
Serial number 7, Chandranath.
7 same, 8 same.
Serial number 9. Serial number 10.
10 not same, yes.
Suyog Herli List number 1. Serial number 39. Bhaskar Babu, HM, HJ. Recording order.
Petitioner in this case, my lord, this honorable court was dismissed for non-compliance of office objection on 21/2024. So we have filed the application for recall, my lord. Humbly praise this honorable court to recall the application so that we can complain the office objection. Pending consideration of IA number 1 of 2024. 2 weeks time is granted of the petitioner to comply with the office objection. Yes, yes, ma'am. Yes, obliged.
The Lord sir directed me to produce the Sagulichit register in comparison to what my learned senior friend had produced to indicate that in the year 2010, a certified copy was issued with regarding to the register, in particular to the entries made at serial number 64 and 65. I just produce this notes. The so-called serial numbers at 64, 65 in the original registers are not available. Are not available.
Not available in sense it has been torn.
It is not torn.
ತೋರಿಸಿ ಸಾಯ್ತು ಕೊಡಿ
ಇಲ್ಲ ನೀವ್ ಹೇಳ್ಬಿಡಿ ಇಲ್ಲ ನಂಗೆ ಹೇಳಕ್ ಬಿಡಿ.
ಅದು ಕೊಡಿ ಅಂತ ಹೇಳಿದೆ ಅದನ್ನೇ. Please pass on the registry. But let me
As found at page number 108 and 109.
Yes.
Please.
Containing order number 64 of 65, 66.
Please.
To be furnished.
I just produce. Page ಹೋಗ್ಬಿಡಿದೆ ಹುಷಾರು. ಹೋಗ್ಬಿಡಿದೆ.
ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಾನು ಬರ್ತೀನಿ. ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಾನು ಬರ್ತೀನಿ. ಹರಿದೋಗಿದೆ ಹೇಳಿ.
I just request my learned friend to show the numbers which are quite.
Page number 108.
Number ಇಲ್ಲ.
Pagination
ಇಲ್ಲ. This pagination is not there. This is there but little illegible. Adralli ಈ entry ಇಲ್ಲ. This is pertains to some other entry, some other villages.
64, 109 ಮೇಲೆ
64, 65 ಇದೆ.
109.
That doesn't pertain to these names.
It's more than sufficient.
ಏನಾಗಿದೆ 64, 65.
I have produced page number 108, 109 and 110.
64 ನೆನೆಸ್ಕೊಂಡು
107, 108. ಯಾರ ಹೆಸರದು?
My lord, Mariappa, the father, Mariappa, the father of the petition herein. It is in my certified copy, my lord, document number 1, along with the writ petition as well as I have produced by way of affidavit also. This is a certified copy, my lord. Annexure in the writ petition, my lord.
Told is 17 acres that you apply. Is. So, 4 acres, even if the court holds that the 4 acres is there.
Page 25, my lord, writ petition.
Survey number 11, 3 acres.
To 4 acres each. ಹನುಮಂತಪ್ಪನಿಗೆ 4 ಎಕರೆ, ಮರಿಯಪ್ಪನಿಗೆ 4 ಎಕರೆ. Survey number 107, B block.
Mailsundar village.
You are appearing for the contesting respondents.
For the contesting.
What is your contention?
Lords, now, this entire 17 acres of property was put for government auction. We have also verified. After all these disputes are being raised, we have also applied under RTI. At no point of time, any revenue entry ever stood in their names. The government has said that this is a government land and put the property for auction. I have purchased the
Right was
property.
granted to whom?
Lords, this was a government property as on the date when it was put for auction.
Huh?
It is not, my lords, I have purchased under an auction.
Government identified 17
Yes,
acres
I have
of land.
purchased under an auction.
All right.
Now, the question is this, my lords. At no point of time, this property has ever been standing in the name of the petitioner.
Hmm.
My lords, there is not even a scrap of revenue document which is produced to show that there was any revenue entry which is capable of being accessed to the other authorities to show that this is a property which was standing in the name of the present petitioners. Not even a scrap of paper at no point of time. Now they are only seeking to rely upon certain documents. My lords, if your lords were to see that register also, lords, if the counting is done from 54, 55 is there. After that, if 10 counts is done, 64, 65 also can be found, but that it pertains to some other property. There is no boundaries. There is no revenue entries. There are no schedules. Auction, I have purchased it. If he wants to, first he has to establish his identity of the property, if at all it was really granted.
I have produced the sketch. There is a report by the Tahsildar. There is an order by the Special Deputy Commissioner.
Now the situation is the government says that there are no records available pertaining to the grant or the Saguli chit.
Then who is right? Whether Tahsildar who has report is right,
Allah,
whether Special Deputy Commissioner is right.
No, kindly see the document. Original document. No, you please see, sir. You please see, page number is there. Page number 109, 109 ಇದೆ. ಅಲ್ಲಿ ಕೆಳಗಡೆ ಆ ಟೇಬಲ್ ಮೇಲೆ ಇಟ್ಕೊಂಡು ಅಲ್ಲೇ ತೋರಿಸಿ. Page number 109 is there, 108 is there, 107 is there.
Kindly see my lord, Lordship, kindly see this one. Lordship, kindly see. This one. Where is the?
Sir, original document, sir, please hold it correctly.
Lordship, kindly see. Then this one. What is?
Allah, sir, I have noticed what the deputy commissioner had said.
Yes,
Please.
then my lord,
Page number 108 and 109.
Paying permission, my lord. Then who is right? Whether the report who has filed before the Tahsildar, he is right, but the finding is right, or he is right.
Allah.
Let there be an inquiry to the fact.
No. If that is, if your claim is right,
Yes, madam.
then you will have to also explain what happened to the revenue entries.
My lord, I am not in the custody of the revenue entries, my lord.
No. You don't have any document with you?
I have produced.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್
Sagudi chit, Lordship, kindly see.
ಅಲ್ಲಲ್ಲ ರೆವೆನ್ಯೂ ಮ್ಯೂಟೇಶನ್ ಎಂಟ್ರಿ ಆಗ್ಬೇಕಾಗಿತ್ತು ಆಮೇಲೆ RTC ಎಂಟ್ರೀಸ್ ಇರ್ಬೇಕಾಗಿತ್ತು
Revenue sketch ಇದೆ.
Index of
Sketch
land,
ಇದೆ.
record
Lordship,
of
kindly
rights,
see.
RTC
Annexure B,
extracts.
sketch.
ಸೊ ದೇರ್ ಇಸ್ ನೋ ಮ್ಯೂಟೇಶನ್ ಎಂಟ್ರಿ
Mutation, except mutation, all revenue records are there. Lordship, kindly see the Sagudi chit. Therefore, no RTC. The other documents, my lord, then certified copy, my lord, it has got the authenticity.
You are
It's
now
a government
trying,
document.
you are now trying to call in question
Yes, my lord.
an auction conducted by the government by the deputy commissioner at the instance of the government.
Yes.
The deputy commissioner could put the property to auction only when it is found that it's a government land. It cannot put an auction of a private property. From the records, they found it's a government property.
Therefore, my lord, certified copy,
Therefore,
Lordship,
you have done nothing. After getting the grant in your favor,
my lord,
if you have not done anything, your name is not found in the RTC records, then what can they do?
my result submission, my lord. The Sagudi chit which has been issued is the title deed. My lord, even the revenue entries, non-mentioning of the revenue entries, my lord, is not the material. The title has to be looked into.
No.
Here, my lord, my result submission, my lord. Here, my lord, I have produced the certificate copy of the Sagudi chit register, and they say, my lord, it is not there. My lord, given in respect of this Sagudi chit issue register, there is a report given by the Tahsildar. Once again, read page 46, my lord. Lakshmi KDC page 46.
We will do one thing, we'll have this matter tomorrow. Because we'll have to raise for reference. Barclay. Release this matter for preliminary hearing tomorrow.
Great. Should I keep the originals with me, my lords?
Yes, yes, yes. ಅದಕ್ಕೆ ನಾನು ನಾಳೆ ಅಂತ ಹಾಕೋತೀನಿ.
Please.
All other matters next week.
Submission, my lord. Submission. I made an amendment application, my lord. There is a one typographical error, my lord. Next matter is made.
Huh?
Next matter it is.
41.
41, my lord.
What is
I filed application for amendment, my lord.
ಯಾವ order? It has been disposed of?
ಇಲ್ಲ sir. ಇದು ಪೆಂಡಿಂಗ್ ಇದೆ. ಮೊನ್ನೆ ನನಗೆ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವಿ.
Correction of what?
Correction of interim prayer and interim grounds, my lord.
You are seeking amendment of the interim prayer?
Yes, my lord.
You are seeking amendment?
Yes, my lord.
Of the interim prayer?
Survey number, only survey number 3/1
Mistake ಆಗಿದೆ.
Yes, mistake ಆಗಿದೆ. Typographical error, my lord. 3/1 ಬದಲಾಗಿ 3/4, my lord. ಅಷ್ಟೇ.
Order on IA number 1 of 2024. This application has been filed at the hands of the petitioners. Seeking correction of a typographical error in the prayer column.
Prayer column.
Full stop. It is submitted that in terms of the documents placed before this court, the survey number should have been 3/1.
Yes, my lord.
And it has been wrongly typed as 3/4.
3/4, yes, my lord.
3/4.
Yes, my lord.
In the prayer
3/4
column.
instead of 3/1.
Stop. Next para. The contention of the petitioners is accepted.
Yes, my lord.
The petitioners are permitted to carry out the correction
Today itself, my lord.
in the prayer column,
Prayer
showing
column.
the survey number as 3/1 instead of 3/4.
Yes, ma'am. Prayer column, interim prayer and.
Prayer ಎರಡು ರೀ.
Yes, my lord.
Prayer column ಒಂದು ಎರಡು ಆಗುತ್ತಾ ತಾನೆ?
ಆಗ್ಬೋದು.
Your lordships kindly, serial number 42, my lord, Tuesday.
ಇದು ಯಾವ್ದು ಡೇಟ್ ಕೊಡಕ್ ಬರುತ್ತೆ? Final disposal.
Yes, next week, my lord, at least.